Any mention?
Yes.
Lordship, I beg to mention item number 45 of the daily list, Lordship. Lordship, I would like to seek for a slight accommodation, Lordship, as Dr. Saraf has some personal difficulty today.
Yeah, objection.
No, Lordship.
You've been adjourning this matter continuously. Which time is this? Adjournment?
Lordship, I did not keep a track of
Yes.
that.
Where Dr. Mukta? He's appearing other side.
Lordship.
No objection.
Lordship, yes.
Okay, 2 weeks, yes.
Lordship may post it after 4 weeks, Lordship.
Why?
Summer break will be there in Guwahati High Court, Lordship. Dr. Saraf won't be there again.
Okay. 4 weeks, yes.
Obliged.
May I please, Your Lordship? I beg to mention item number 43, Your Lordship.
Lordship, there's an interim order has to be continued, Your Lordship.
Lordship, then in that case, they were asked to renew the bank guarantee, extend the period of the bank guarantee. Till
Yes,
when
yes,
has it been extended? That has not been informed.
Yes, take
Yes,
down
Lordship.
Mr. S.G. Saikia to this prayed for adjournment due to unavailability of the arguing senior counsel. He prays a matter of 4 weeks due to the he prays matter of 4 weeks. Further prayers made for continuance of interim orders stopped. Next by Dr. P. Agarwal appearing for the respondent number
3 and 4.
3 and 4, however, submitted that the continuance of interim order is subject to the renewal of the bank guarantee.
Lordship, and they may inform us till when has it been extended.
And there seem to be
Yes, Your Lordship.
the respondents. Stop. Ms. Esaikia submits that the bank guarantee has since been renewed. However, is directed to inform the respondent 3 and 4 officially.
Lordship, that will be better.
To be communicated to the response 3 and 4 officially. Right.
Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 43, Your Lordship. I pray for 2 weeks time, Your Lordship.
It'll be 4 weeks. It'll be 4 weeks then, Your Lordship.
What is the matter about?
That
So we're challenging the
recruitment,
advertisement,
Your
Your Lordship.
Lordship, by the,
Recruitment?
for a post of ranger, Your Lordship.
Why asking for time?
Some difficulty, Your Lordship.
What's the difficulty? You can understand, but then just it can't be a blanket license to just take adjournment. Otherwise, this list, their weekly list, they come up in the beginning of the week, and all councils are aware that these matters are going to be listed for hearing. Yes, 2 weeks.
Obliged, Your Lordship.
Hallelujah, bless Lordship.
Yes,
Lordship, I beg to mention item number 39.
yes.
Here in this case, Lordship, I am for respondent for
What happened to the settlement?
Yes, Lordship. Title 2 is there. It was supposed to be settled on 28th last month, May, but it happened to be a holiday on that day, so they have deferred to 29 this month for settlement, if any.
Who's for the petitioner?
Petitioner happiness.
Where's the petitioner? Mr. Siddiqui.
Who's that?
Yes. Donan appears for the petitioner. Mr. H. Nankau submitted that the date for settlement had been fixed on 29 May.
No. It was fixed 28. Now again 29 this month.
28
June.
May, which, however, the same being holiday, has since been rescheduled for 29 June.
Yes, Lordship.
Yes. Record yes, sir. Mr. has no objection. This is a matter after in the first week of July.
Yes, Lordship.
Please, Your Lordship. Lordship, I beg to make a mention of item 34, Your Lordship. Lordship, I'm paying a week's accommodation, Your Lordship, in this matter. Senior is out of station, Your Lordship.
There's got to file affidavit, no?
This matter 34, yes, Dr. Mozika.
But they're taking time, I think, for years now for filing additional affidavit. The other connected matters are disposed of.
When did you join as a lawyer?
Lordship,
Which year did you start in practice?
21, Your Lordship.
21. This case is 17. So,
I think it can be disposed on the same terms. The other contempt of disposal.
Next week, Your Lordship.
you agree?
Lordship,
You
next week,
discuss
Your
same
Lordship.
terms as the earlier case. Did Mr.
And they'll be at
Patak's case.
liberty, my lord. They can hesitate by way of
My apology, Your Lordship.
procedure.
I'm a little handicapped, Your Lordship. I'm not the briefing counsel in this matter, Your Lordship.
Okay, we'll have it after 2 weeks. It's a doctor matter, right?
No,
Lordship,
madam.
that contempt.
This is That ORL, Assam Rifle ORL.
Oh, 35 also.
There are two club matters, my lord. One has been disposed of by lordship.
And this 35?
35 your lordship, is that Dr.
Dr. Matters.
35 to 37 your lordship.
Okay, after 2 years.
Highly obliged.
So 34 to 37.
Yes.
Highly obliged your lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 40.
Number?
40. I pray that this matter may come up after 2 weeks, Your Lordship.
No objection, Your Lordship.
Yes.
Highly obliged.
Your Lordship, I beg to mention item number 38, Your Lordship.
Number?
38. I'm praying for 2 weeks' time, Your Lordship. No objections, my Lord.
Mr. Changriso?
Yes, Your Lordship.
You're there also, Mrs. Naitang? No. Yes. Yes.
Obliged.
Make mention of item 44 your lordship.
Not sparing any, all the items in the list.
2 weeks time.
What's the matter about that?
This land your lordship.
matter?
Yes, your
Yes,
lordship.
Your Lordship. This was sent for mediation also, Your
But it's
Lordship.
failed, your lordship.
As count mediation is failed after it's not been listed. First time.
Yes,
the second
this
time
second
after
time, your lordship, after
mediation,
mediation.
Okay, yes.
Your lordship.
Yes. 2 weeks.
Your Lordship, I mentioned item number 46. I'm from respondent number 2, Your Lordship. I'm praying for 2 weeks' time, Your Lordship.
Why?
Because the conducting council is not
It's a
keeping well.
freezing matter.
Yeah,
It's
Lord,
I mean,
not freezing, Lordship. Here the petitioner has made some RTGS transaction. The RTGS transaction was
any
made,
urgency is there?
my Lord,
If urgency is there, he's. Why? What's wrong with the council?
She's not keeping well, Your Lordship.
SBI and the Axis Bank is the main party, Lordship.
You have Axis Bank or Reserve Bank?
These
Who's
are
with Axis Bank.
Axis Bank, they have filed the affidavit, Lordship, but on the last date also, when the matter was called, they were not present, Lordship. But affidavit has been filed.
We'll go on affidavit, fine. Yes. When?
Can it be on 6th of July?
Yes, 6th of July.
Hello.
Supplementary list item number 1.
May it please, Lordship. Lordship, this is a contempt petition, Lordship, and can you see the sequence of events, Lordship?
This is
Contempt petition, Lordship.
contempt.
Lordship, kindly come to page number 10. Lordship. Lordship, I am the acting Lingdo, Lordship. Acting Lingdo. And this is my sanad issued by the same of
You're
Novo
still
Support.
subsisting.
Lordship.
You're still acting in the.
Lordship. I'll show, Lordship. I'll come to that, Lordship.
Then
Issued on 22nd July 2024, Lordship. Subsequently, Lordship, the next page, Lordship. Page 13, Lordship.
yes.
Page 13. My committee was approved by the same, Lordship.
Yes.
Thereafter, Lordship, because thereafter, Lordship, this I was removed from this office by this same, Lordship. Same. That is at page 23. The type copy, Lordship, page 23. Original is page 22. Annexure 4. Lordship. I was removed on 2nd August 2025, Lordship.
Okay. Yes.
And thereafter, Lordship, I file a complaint before the KHDC, Lordship. That is on the next page, Lordship, Annexure 5.
Yes.
So, and pursuant to this, Lordship, KHDC has passed the stay order, Lordship. Can you see this page 30, Lordship, Annexure 6? The last para, Lordship.
Yes.
Therefore, the executive committee so-and-so is
Okay, then
hereby
what
pleased to
after that?
stay, Lordship. And subsequently, Lordship, after this order was passed, Lordship, this on the next page, this is the order, Lordship, which was passed by this court, page 31, Lordship.
Yes.
This Shri Bringlang Ding Paliar approached this court challenging this order, challenging this stay order passed by the district council, seeking to set aside and quashed. However, Lordship, by this order dated 11/9/2025, Lordship, this court has not interfered with the stay order, Lordship. However, only an observation status quo order was passed, Lordship. Kindly see paragraph 5 and 6, Lordship. Paragraph 6, Lordship, as the parties are present in this court today, they are put to notice to appear before the EC on 26 so and so. The executive committee thereafter shall dispose of the matter in accordance with law. And until further orders are passed by the executive committee, it is ordered that status quo shall be maintained as on today, Lordship. Now, it's very clear, Lordship, this order has never interfered with the stay order passed by the District Council, Lordship. So that stay order is operating, Lordship. So, Lordship, subsequently, at page 42, Lordship, page 42, this is the type copy, Lordship. This is the public notice issued by the aim of Novo Sabha, Lordship. Again, Lordship, here what he has done, he has validated the removal order, Lordship, that 2nd August 2025, Lordship. Over and above that status quo order, Lordship. Kindly see, Lordship.
Then when you come by another writ petition?
No, Lordship, because the status quo is in operation, Lordship, and he is a party there, Lordship.
Heard Mr. Her for the party. Issue notice returnable in 2 weeks. Yes. Stuff to be taken within 3 days. But it's also permitted to affect personal service on the respondent. Yes.
Lordship, one more prayer, Lordship. This matter is it's connected to this item number 25 of the main list also, Lordship, because it's arriving violating the same order by the another.
So you're appealing for acting for the
acting link door, Lordship.
Acting link door.
Then why are you doing this? Your statutory orders are there.
Lordship, when I approached this honorable court, I was
notice.
I've received notice, Lordship. In
For
25.
contempt.
No.
In 25.
No, in item number 25.
We'll take it 25 when it comes up, please.
Lordship.
Item number 2.
May I please, Your Lordship?
Yes.
This is regarding the release of the family pension, my lord. I am the first wife of the deceased employee, my lord. And I am my husband was working as the BSF personnel, my lord. He having 3 wives, my lord. Now one wife has been filed writ petition before the Calcutta High Court, which is being pending. I am before this honorable court with the release
now
of
the one there are 3 wives. You are the first wife.
I'm the first wife.
Second wife filed petition before
The
Calcutta High
second wife, my lord, the whereabouts of the second wife, I'm not aware.
Court. Third wife filed for Calcutta High Court.
Third wife, she approached before the Calcutta High Court, where the matter is pending, my lord. And I'm the first wife. I am running pillar to post to release the pension, my lord. I am seeking only my 50%, my lord, which is the under the law also, my lord.
Lordship, he is on next before courtroom number 1.
How can you be sure that the second wife doesn't just
my lord, as per
appear from somewhere?
my instruction is I am not aware about second wife, my lord. What about the pension act? Because, my lord, this is the third round of litigation before this honorable court. On the last occasion, my lord, I approached before this honorable court with regard to the limited prayer, my lord, regarding the, my lord, the total amount which is pending, so that we can file a succession. Because the department, on several occasions, department has issued letter whereby stated that succession certificate will be required. So we'll approach Bagmara court, my lord, in South Garo Hills, my lord. Because of the writ petition which is pending before the Calcutta High Court, the matter was finally withdrawn, my lord, the succession matter, my lord. Then we have to approach before this honorable court for...
Where did he die?
My lord, in the year 2001.
No, where?
My lord, at West Bengal.
With you? No, with the third wife.
With the third wife, my lord. But in the all documents, my lord, in the all service documents,
your name is
my name is there, my lord.
Yes, but Ms. SKSA, issue notice returnable in 3 weeks. Ms. Emericham, as present, Vice Dr. Invoice present, we have orders upon the accept notice. no further notice is called for just after 3 weeks.
Lordship.
For instructions of affidavit.
My lord.
You didn't make the third party here?
No, my lord.
Why?
Because I am claiming 50%. The rest 50% will be subject to the outcome of.
To your detriment. Yes.
My lord, yes, my lord. Outcome of the Calcutta High Court's order.
Are you a party in Calcutta High Court?
No, they have not made a party to.
So you're not a party there, and you've not made a party here.
My lord, no, my lord. Because my
Then
lord.
suppose some orders are passed from there which are conflicting to your orders passed with conflicting. What will happen? What will be your remedy?
My lord, in that situation, my lord,
In that situation,
my lord, I'll.
Anyway, who's in not sitting advisory
claim only
capacity?
50%, which is my lord.
Okay. Whatever it is,
Yes,
if she is a claimant also.
I'll make. I'll
No, it's not that.
them.
Just to ease the.
Yes, my lord.
You see, if it's a pension matter and these people or these widows are entitled to it,
Yes,
should,
my lord.
you know, the most fastest possible way, you should be given help.
Yes, my
That's the
lord.
only thing. The only concern of the court.
My lord,
And council should take that into consideration,
my lord,
which is more efficacious
my lord,
than just kicking the ball around.
my lord is correct.
Yes.
I'll take instruction and my lord. I'll your place.
What is this?
Item 3.
My lord.
May it please your lordship. Lordship, here the petitioner is the Nukma of Alagiri Aking, lordship. Here in the year 1997-1998, some portion of land has been taken by the department.
Which year?
1997 to 1999, lordship.
By any document?
There is no document. There is no oral with a promise that they will keep some construction material for the purpose of construction of road, lordship. And later on, they have kept on occupying the said land, lordship. Now they have constructed permanent structure there, lordship. Now, whatever may be the case, lordship, at least I should be given a reasonable compensation, lordship, because they have not
Where
given.
the details? Where have you put the details?
My lord,
Where have you mentioned the details of the land and occupation?
my lord, I have given that some map, lordship. Annexure 2, lordship.
Then you file a civil suit for eviction for recovery of possession.
My lord, let them to come. They say whether
What
they
will
have.
they come with what?
No, my lord, they cannot
You want
take.
them out from your land,
No, they
correct?
cannot take any land. I just want that compensation, lordship. I am not seeking for eviction, lordship. If they give reasonable compensation,
Yes.
is all right,
Allow me
lordship.
to take instructions, your lordship.
But Mr. S.C. Sheikh, the company issue notice. MSZE no country.
For all the respondents.
As present, acceptance of all the respondents. No further notice list after 2 weeks for instructions affidavit.
Obliged, your lordship.
Item 4.
My lord, here, my lord, I am challenging, my lord, an order of suspension, my lord. The
How many
petitioner
challenge order suspension?
suspension, my lord.
Why?
Only on the ground of corporal punishment to one of his students, my lord. He was suspended.
That's illegal now. You don't know what.
That is, my lord, the allegations, and if my lord will see the impugn order, that is at page number 5. That is at annexure 5, my lord, page number 19.
Yes.
It says, my lord, whereas it revealed from the disciplinary inquiry on 26/8/2025, a student of class 6 was severely beaten in presence of his father and other students, guardians during mark sheet distributions, caused great distress and serious act of misconduct, insubordination, indiscipline, dereliction of duty, and FIR was also lodged against you in Tura police station that day. Besides that, several complaints submitted by students regarding your teaching methods and attitude, your behavior towards seniors, other colleagues, especially lady staff, improper. And whereas it is considered necessary to ensure a fair and impartial inquiry and to maintain discipline in public service, now therefore, in exercise of power conferred under Rule 7, Chapter 4, Appendix 1 of Assam Education Department Rules and Orders, Volume 1, as adopted by so-and-so, the undersigned hereby place Sri so-and-so under suspensions with immediate effect until further orders. During the suspension period, headquarters of Sri Nirmal Chaturpadhyay shall remain at Tura, and he shall not leave the headquarters without prior permission. Prior permission of the owner.
What's wrong with this
Now, my
suspension
lord,
order?
the order, my lord, which was passed under following this Assam Education Department Rules and Orders, my lord, this is illegal because Meghalaya Education Act 1981, my lord, which is governing in this field, my lord. My lord, may kindly have a look at the
No, we won't look at that now. We're looking at the date of the suspension.
And moreover, my lord,
When were you suspended?
he was suspended
2nd September 2020.
Yes, and my lord, he was, and by the same order, my lord, he was directed not to leave the jurisdictions of this court, of that particular station, my lord, Tura.
Anyway,
And
but Mr. Anson,
my lord, I have filed a miss case, my lord, for suspension. For 9 months, my lord, he has been suspended without a notice, my lord.
doesn't matter. Let him
My
take
lord,
instructions.
my lord, if I can complete my submission, my lord.
No, I mean,
my lord, may kindly see the provision. That is very important as far as
that'll be a substantive matter of your case. Are you seeking
Entire-
final relief?
my lord,
Are you seeking?
my
if
lord,
we give a stay,
my lord, may kindly
on
see
prima facie satisfaction.
if the order is
please listen.
my lord.
If we give a stay now, on consideration submission, the prima facie to establish a case, the wrong provisions been applied. That means you're getting whole relief in the interim stage. We're not allowing that.
If I can,
yes,
if I can, my lord,
they're going to issue notice.
this is without
Yes, present acceptable.
giving me an opportunity to reply, my
1
lord.
to 6. You will get the opportunity here. Yes, notice to issue on number 7. And within 2-3 days, just after 2 weeks for instruction the affidavit is. Wait.
All right.
5.
Please, Your
Yes.
Lordship.
And
Lordship,
what
I'm
is this
praying
MS,
if this matter may be taken up at the end of the board, Lordship.
What's the matter about?
Lordship, in this matter, we're grieved by the termination letter, Lordship.
Where's the impugned cancellation letter?
Lordship, learned senior counsel is leading this matter, Lordship.
The
Dr.
brief will be belong to
Moses.
receive. Yes.
After some time.
We seek some interim relief. You ask for interim prayer. Yes, interim.
The operations have already been taken over by me.
No, I seek some interim. I seek interim.
To stay the.
Then we'll let him come then.
After some time.
No, I thought this is for notice.
No,
yes.
no.
Yes, ma'am.
We will hear on interim.
Item number 6.
Yes,
Please, Your Lordship, this is that matter yesterday, Your Lordship, regarding
Sorry. Go ahead.
striking of the name of the applicant, Your Lordship, while retaining the designation of
striking out the name of the applicant.
My lord, I am
designation
objecting
will
to
remain,
this
Your
as per instructions of my client, my lord. There are 2 instances. The first instant on the unauthorized transaction that happened, my lord. First, he said it was validated by a phone call. Now, I did not make that phone call, my lord.
Why are you arranging him as a personally, not by designation?
Because, my lord, he has.
Whatever he did in discharge his duty.
He has done in his own.
Did he act malified in any manner?
Yes, my lord, because, my lord, he could have.
Malified, you're alleging malified.
Yes, my lord, I am, because this is the instruction of my client. First of all, my lord, there were 2 instances where he could have stopped the transaction immediately, but he didn't. First, there was a phone call which was made to the bank saying that this is me, but it was not my phone call. I believe that there's something called as my lord, SIM shadowing or call mirroring, mirroring, sorry, my lord. So, my lord, there are 2 instances, and even the bank manager has disclosed this to the petitioner, saying that the voice recorded confirming the transaction did not belong to the petitioner. He could have said that, he could inform that to the cops, my lord, to the police, investigation is, he did not. The second transaction was through email, and I had already informed the bank that my emails was hacked, my lord, on the first day itself.
Bank before the transaction happened.
Yes, I have.
Right, but that your email account had been hacked.
Yes, I have.
And even the earlier occasion with regard to the what do you call it, the voice.
Yes, I did.
You already informed him that it's not my voice.
I informed them that my phone was not working, the UPI app was not working. I had told the bank manager said come back on the 23rd July 2005. The reason being because I did not have my ATM card. I had already informed. On the same day, my lord, two beneficiaries were added to my bank account, saying that
were not known to you.
Not known to me. And that's the reason.
Lordship, the prayer,
the conduct of
none of it in the prayer is mentioned, Lordship, against the bank.
Mentioned
all the mentioned in the body of the petition.
Nothing,
yes, my
no
lord,
pleadings, Lordship. The prayer itself.
2 instances with regard to this, it amounts to
nothing. None of the prayers are against me.
Of the branch manager.
In person, nothing.
My lord,
it's always directed against the bank.
Let me reply to this striking of the name, my lord. I'll bring this on record. I have the instruction, and the reason why he could not come, my lord, to file, we could have filed the affidavit, the reply today, but he is financially constrained. He could not make it to Shillong. He's from Nongstoin, my lord, the petitioner.
Well, you don't file the objection as yet.
No, my lord. The reason.
Put the objection on record.
Yes, my lord. I'll do it. I'll do it as soon as he comes down from.
Miss case number.
Miss case
172.
172 2026. Stop. In this application for striking out the name of the applicant who has been named personally in the petition. MSOI Bank submits that he may be allowed to file an objection to the same, as certain acts which had been committed by the applicant point towards personal liability in discharge of his duties. Accordingly, 2 weeks time is allowed.
Yes, sir.
Yes.
Who's obliged, my lord?
File it.
Yes, my
If
lord.
that is the case, then
I'll bring it on record, whatever
yes.
instructions I have.
7.
Please, Lordship. Lordship, I have filed a application numbering numbered as 180 for impleadment of the Registrar Respondent 6.
Yes. Who's appearing? No objection.
No objection, Lordship.
There's in this case 180/2026. There's an application for impleading the registrar of East University as party respondent in the connected petition. So, this next one was objected to by the counsel for the respondent. The application of falling allowed. The registrar in the area is respondent number
6.
6 in the WPC number 181/26. Registry to make the necessary addition. You'll accept notice.
Yes.
Yes. Ms. Ibla also for respondent accepts notice on behalf of the respondent. No further notice required. You want to file affidavit? That's no further record. This case. This case allowed disposed of. In the main case is listed today.
Main matter is not listed today.
Right, your lordship.
Daily list item number 1.
My lord, I have taken
Yes,
steps.
you've taken steps.
Yes, ma'am.
Lordship, I'll be entering appearance, your lordship.
Yes, start.
Lordship, we haven't filed a power, your lordship.
You haven't filed a power.
We'll file during the course of the day.
When do you want it? After some urgency is there?
No, man.
When?
After 2 weeks.
This is there's only one respondent.
Two, your lordship.
Appearing both of them.
Both.
Ms. S. Kiriam Suresh entered appearance on behalf of the respondents 1 and 2. Such notice is complete that he prays for the matter after 2 weeks to enable him to study the matter. Yes. How much pray allowed this after 2 weeks? Yes.
2.
Lordship, please, your lordship.
So we'll close it.
Lordship, I pray for Passover for today, your lordship.
No, we'll close this matter.
Lordship, tomorrow, your lordship. Senior is out of the job.
Sort is in respect of the stay on
Passover for today, my lord.
Yes.
What did you
Do you have any other grievances? You can file a fresh petition.
Lordship,
We'll
Passover
close it.
for today, your lordship.
Let's just see how many times it passed for the day. Okay. Yes, 16:10.
Even the last order also indicates that there will be
Now
no
there is one submission made by you on 28/10/25. Mr. S. Kiriam, that council petition submits that though instructions have been received, the same are with a senior. Very smart submission. Then again, on the prayer Mrs. Kiriam, 13:11, there's a matter of 26:11. Then 26:11, at request Mrs. Kiriam, then a counsel for the petitioner, this on 11:12 or 13:11. Then next, then S. Khatun, she's not appointed to apprise of court, and the instructions received, this on 11:2. Then S. Kiriam on 11:2 again asked to for 27:2. Then so this matter
with an observation that no further adjournment should be
repeatedly adjourned by the petitioner from 16/10/2025 onwards.
on Friday, your lordship.
On the prayer that they may be allowed to obtain instructions from the petitioner. Yes, Mr. Pandey?
Even the last order is clear. The last line. It is
Yes.
expected on the matter will
Yes,
not be adjourned.
by order dated 3/6/2026, this court observes that it is expected that the matter be not adjourned further. stop. However, today Mr. S. Kriam again has renewed a prayer for adjournment. Will be which time is this if we count the order sheets? Even you can't count it anymore. Yes.
Friday, Your Lordship, as a fixed matter.
In this view, the matter, the matter having rendered in structure is closed, leaving the petitioner to take appropriate action in case of fresh cause of action. Yes.
Okay.
You count from the order sheet how many times you took time.
Item number 3.
Your Lordship,
yes.
On the last date, the governing body of the college has filed the affidavit, Lordship. And in the affidavit, they have annexed one resolution, Lordship.
One
resolution of the governing body, and that was not part of the challenge in this writ petition, Lordship, because that copy was never supplied to the petitioner, Lordship. So I need some time to have the instruction.
Committee.
Whether I need to.
I'm for managing committee.
I just.
That is response number 6.
Yes, madam.
5 is what?
Is filed by the 4, Lordship.
Response number 4, madam.
4.
4 is?
4 is the managing committee governing body of the college.
Lordship.
4, okay. N. Lamari is your junior.
Yes.
So I need some instruction whether I need to amend the writ petition.
Sheikh submits that in the affidavit of the respondent number 4, a certain resolution dated
This is the same submission which he has given on the last occasion also, and today the matter is fixed, my lord, for instruction, my lord.
Oh yes.
Now,
my lord,
he say that.
Yes,
he
lord.
could have renewed his prayer, but not that, my lord. He came to know today.
Not. I'm not saying that I have received it today.
Oh no, he's only read the N. Lamari will file the last date.
Because yes, lordship. After
Anyway,
that I have
resolution dated.
Resolution dated 21st February 2025, lordship.
25 has been annexed. He prays without to obtain instructions in this regard. According to this, after 2 weeks.
Lordship.
For further order.
4.
Hello.
Except 6, my lord, pertains to the disability lump sum matter, my lord.
How come it's come again so?
Lordship, these are different matters, Lordship. The other one which...
No, that last time, this matter had come last week, correct?
No, Lordship. Those are different, Lordship.
Okay, yes,
My lord,
please continue.
In item number 12, my lord, affidavit in
That is WPC number?
But the other one is WPC 26, Lordship, the one which came last week.
No.
12
Today 12 is WPC number?
464 of 25.
464.
Lordship.
464 of 25, that affidavit in opposition has not yet filed, my lord.
Others?
And the similar batch of petitions.
One second. Wait. Now, last date to file affidavits in WPC 432, 437, and 464. Now, 432, 437 has been filed.
432 is different subject matter, Lordship. 432 pertains to red ink entry, Lordship.
And why is clubbed together here?
Lordship, it has been tagged together since day
Except 6, my lord. Item number 6 is different, my lord. 432.
432 is different.
1. Lordship, different.
My lord. Affidavit has been filed there.
No, Lordship. I'm praying for some time in item number 6.
That is segregate 432.
Lordship. Lordship, I have one prayer, Lordship, in all of these connected matters which pertain to lump sum compensation. As we've prayed earlier also in WPC.
In 26, you'll file one affidavit.
One chart, Lordship, comprehensive chart.
Which are the other numbers you kindly give the court master?
Lordship.
Yes,
WPC 26 of 2026, my lord.
And the others also.
Lordship.
Yes,
my lord,
when the matters,
has-
yes, MS Emery Chang, learned counsel for the respondent by Dr. N. Mozika, today submitted that as the matter concerning grant of disability pension is pending in many similar cases, he prays that all these cases be listed together and the respondent permitted to file a chart, yes, to assist this court in the matter. Of the prayers allowed. Mr. V. Kumar, learned counsel for the petitioner, has also apprised of court that 432 of 2025, which is listed today, together other matters, pertains to a different subject matter, that is a red ink entry. He prays that this matter be segregated from the badge matters. Prayers allowed. Stop. Next line. Accordingly, the learned counsel respondent is directed to supply a list of the connected matters regarding disability pension to the court master in the course of the day, and all these matters be listed on
After 3 weeks, Lordship.
after 3 weeks. Yes.
My lord,
432
similar prayer for
and 432
432, I'm praying for some time, Lordship.
and 42 Lafajong. In this matter, which has been segregated in batch matters, the learned counsel respondent prays for and allowed for the 3 weeks time to file affidavit. Just thereafter. Yes.
Highly
my
obliged.
lord, similar prayer for item 17,
17
to 20, my lord.
20.
For disability.
Lordship, all disability.
Yes, my lord. 17 to 20, my lord.
Now, what in 7 to 20, but the jo lists these matters pursuant to as direct by this court in order dated past other matters, list these matters together and next day. Yes.
My lord.
Highly obliged.
Give your lordship.
20 years. Yes.
14.
May it please your lordship, in this matter,
Once again, let the file come. Yeah.
in this matter, your lordship, will be filing a rejoinder affidavit in the course of the day, your lordship.
Yeah, for respondent number 6. Yeah.
You already file affidavit.
We've already filed.
Yes, MSRC, RS Karshien. What's the
Kharshiyang, yeah.
Karshien, sorry. Submit rejoinder to file at court of the day. Only this is a matter for hearing up to 2 weeks.
Highly obliged.
15.
May it please your lordship. Your lordship, this matter is similar to WPC 274 of 2025, where your lordship had given us 30 days time, extended the time by another 30 days to complete the job card verification as well as hold the elections.
It's the same village.
Same village, Maula Gandhi village, your lordship.
When was where's that order?
That order is in the other case, your
Which
lordship.
petition is it?
It is WPC 274 of 2025, and there was a miss case which was disposed of on 20th May, your lordship. Yes. 274 of 2025 is the WPC, your lordship, and the miss case is WPC
274
of 2025.
Okay.
And the miss
then?
case where the time was given to us, your lordship, is WPC number 149 of 2026.
Miss case 149, 26.
Yes, your
Is
lordship.
that correct? You're there in the matter also.
I'm
Who's
not.
appearing that matter?
I'm not there in the matter, lordship.
Who's appearing in
Mr.
matter?
Pasanti was there, your lordship. And by order dated 20th May 2026, your lordship was pleased to grant us extension of time by another 30 days.
Yes, take down.
So,
MST Young EB Leonard EHG has submitted that in connection with a related matter, which is WPC 274/2025.
yes, your lordship.
Pending consideration before this court.
This matter has already been
Wherein-
disposed.
Wherein orders have been passed in a connected miss case, being miss case 149 of 2026 for completion of the job card verification of which village?
And holding of the
Maula Gandhi
elections.
village.
Maula Gandhi village.
Morakandi, yes. For verification of the Morakandi village job card holders and for holding of elections. This matter be tagged together and listed after.
Lordship.
Yes.
I submit.
Lordship,
in
lordship, this matter has already been
in this matter,
disposed.
lordship.
Who fight dispose of?
Yes, your
Lordship, in
lordship.
this
The miss
matter,
case 149 is disposed of, your lordship.
We are praying for election, my lord. In fourth part of Maula Gandhi, an election has been declared
So
on 9th of.
when are you said 274 still pending, correct?
274 is being disposed of, and we filed a miss case for extension of time, your lordship.
Oh,
Because,
then-
yes, the state, your lordship.
This is linked
Because of the
also
disturbance in Garo Hills, we couldn't complete the job verification. For election.
Within 30 days of though the stop next paragraph though both the WC 274 and 149 has been disposed of, stop the respondents are to apprise of court with regard to the action taken. Yes. And they seem to be furnished in the present case. Yes. List after 2 weeks.
2 weeks.
Lordship, I'll withdraw this matter because in
why?
Lordship, in this matter, our prayer is very limited to held. Yes, to held election.
Then there is no point.
Then there's no need for any order.
Yes, Lordship.
Yes. MS Tisha said at the beginning, with Emira Manor Council prays without to withdraw an instant matter as this prayer as the CM not objected to by the Council and the AG matter stands supposed to withdraw.
Yes.
16.
May I please, Your Lordship? Your Lordship, we have already filed our affidavit in rejoinder.
We have received a rejoinder affidavit.
What's the hearings?
Your Lordship, I have one small submission to make. Your Lordship, there's respondent number 10, which is the same of Sora. Seems that it's an important parties, Your Lordship. Here, so till date he has not entered.
Nobody tell you how important he is. They made him lose all importance. Yes.
They've been leveling allegation that they don't have the power, Your Lordship. In another case also, Your Lordship has directed them to file affidavit.
Who's appearing for 10?
I have no idea, Lordship. Till date they have not
Who's
entered
appearing for
appearance.
number 10? Mrs. Eames appear, correct?
Yes, Your Lordship.
But here he's a petitioner.
Petitioner, Your Lordship.
What's with Your Lordship?
He's appearing for Deputy CM, Acting CM, Petitioner.
Against his aim also.
Against CM, yes.
We are for the petitioner, Your Lordship.
No one's appearing for 10.
They're not even, he's not even aware.
What will this matter then?
Your Lordship, his appearance is very important. Your Lordship, there's a certain action that from the CM that has gone against me, Your Lordship.
Yes, one thing, then you take fresh step on 10.
Yes, Lordship.
Acting CM, whatever. Yes, it is noted that though rejoinder has since been filed by the petitioner to the other affidavits filed by the respondents, there is no record of service being effected on respondent number 10. Stop. Though the office respondent 10 has been occupied in an acting capacity, the petitioner directed to take steps by ED and by personal service within 3 days. Yes. Just after 2 weeks. Yes.
Lordship, there's an interim order.
Interim order will continue. Yes.
Yes, Lordship.
21.
I'm praying for some more time for instruction, madam.
You will have no objection.
Short time may be given, my lord, at least 1 week.
Short time? Yes. Gratuity? Yes, I've prayed for the 2 weeks time allowed.
22.
Please, Lordship. Here the private respondent have already filed their affidavit, my lord. In their affidavit, they have not mentioned the genuine reason why they were opposing my wine store. They have only stated that another gas metric that wine shop, there say only the decision is that they will file a.
Firstly, my lord, the permission, my lord, issued by the Deputy Commissioner is contrary to Rule 191 of the Assam Excise Rules, my lord.
That had already been discussed, my lord.
No, my lord.
Regarding consent?
My lord, yes.
You're not in the vicinity also.
Yes.
Well, I'm
You've given 100 meters.
My lord, even
Then
so,
you
my lord,
are allowing illegal
Your
wine
Lordship,
stores
I'll
to
place
operate
the
there. Unless
provision,
you
my lord.
also in the business of operating illegal wine.
No, my lord, I'll show the
Illegal,
provision, my
you are
lord.
saying by your own submission before the respondents that illegal sales going on in the vicinity.
My lord, my lord, I have wrote a representation before Deputy Commissioner.
Then why, if illegal is going on, why don't you allow legal wine store to
Even regarding, my lord, the bar, my lord, it has not been within our knowledge. My lord, regarding the bar, my
The
lord,
bar exists there.
we don't know, my lord, that it is a bar, because at the time when the opening and the blessing was done, my lord, they were called for and they were informed it is a restaurant.
Leaders were called to bless that place.
My lord, kindly
Yes,
have
yes,
my
they have
representation, my lord.
They have stated that this because it was called by the church leader, then they have blessed it. Then that's why
the bars are
they will allow. Yes, this is the meeting on
have page 42
19th
of my
March
application,
2026. They have clearly stated that particular bar was not complained because that bar was blessed by some church leader. It is mentioned in that particularly.
To that aspect, my lord, I have filed this affidavit, my lord, bringing on record certain documents indicating, my lord, the factual aspect as to the awareness, the
we
existence
can't
of the
go
bar.
under whims and
My
fancies
lord.
of. See, the thing is that you have your because your own rights, but they also should not transgress, like where you affect the livelihood of other people who have
No, but again-
obtained requisite permission just by making what do you call it, opposing for the sake of opposition. And if you allow another bar to operate and you
No, but
complain
against
that
the bar, we have taken action,
illegal
my lord.
sale,
We have taken steps against the bar
illegal
as well.
sales going on.
Against even, my lord, even against the
They
illegal
cannot
sales
take action.
and the bar.
It's the government to
Where's
take
the
action.
affidavit? Let's see. 4 to 7, 36. What is this file? File here.
And one of the respondent, 5 very expired also. The president who make a complaint on last Saturday. He expired. She expired.
Who expired?
That president, respondent number 5. On last Saturday, she expired. Silmi.
How do you know?
Because I was sent, informed by the petitioner. They have sent so they even the funeral.
Where is this from?
My lord, can I have page 43, my lord?
Of your affidavit?
No, but can I have first the annexure A? Page 14, my lord, is the translated copy. Page 14, my lord.
Page 40.
14.
Of the affidavit?
Yes, ma'am. No, look, this is the emergent meeting which was held on 21st 1st 2025. Number one of the agenda, that is with regards to the opening of a wine shop in Walbakre area. No, pursuant to this, on 6th of March 2025, that's on page 18, annexure B.
1 second. Page?
Page 18, my lord.
It's given a different page, and my page is
18.
My page 18. This is your affidavit. Page 18. 17. Page 17.
This is my complaint before the deputy
So
commissioner.
if those people staying around don't complain, who are you to complain?
No, my lord, I am one of the.
Where's your church situated? How far from the proposed wine store?
Well, church is situated somewhere, my lord, not within the.
Yes,
100 kilometers, yes.
That's that
But-
119. If you want to, where the excise act?
No, no, I'll
119,
clear that.
that means the consent has to be taken from the vicinity.
Vicinity, my lord, and from
vicinity you've
the
written
local
here,
residents as well, my lord.
it's opposite BSF camp. At the entrance, the VIP related to residents of Chief Minister. Yes.
I have flagged the provision, my lord.
When was this meeting held?
My lord, meeting was held on 20th of March 2025, my lord. That will have annexed at annexure D, page 22. where has been spot inspection has been conducted in the presence of the NOCMA, the petitioner, as well as the various stakeholders.
Where do you extract from the northeast
This
local acts?
This yes, I've got from the net.
Is Assam publication or Meghalaya publication?
Assam, my lord. I've tried from the but this we have adapted the Assam.
So Assam, is it by incorporation or by reference? Adaptation of Meghalaya.
The adaptation, my lord, please.
You know the difference between incorporation and reference?
Yes.
See, one thing with Sama, we can't have double standards. That's the only thing. If equality or equity has to prevail, then if you allow, they complain about legal wine and you allow other bars to operate in the vicinity, whatever is not a question is established illegally. Shifting or due permission, he shifted from Janjal to wherever is shifted now. All been excise authorities were got, even depreciation was informed. You know, you're not in the vicinity. So, yes. See, this one is different from the original act. Where the court asking whether it's by incorporation or by reference legislation. You understand the difference in the incorporation and reference?
But again, what the
see rule 191 here?
Yes.
It says Gaon Panchayat. So see the 191 which is in this the original one.
1912B, my lord. The owners or occupiers of the neighborhood.
Yes. Where is that 100 meters in the rules? Where is that, Mr. Sama?
Your Lordship, I tried to find out that case, but on the last on the order,
there's a rule. It says within.
Yes, that is within as per the rule 183 to clause 2A. It says that within the 200 meters away from other is 300 meters. So in the order it is stated that my shop was actually approximately, it was more than 200 meters away from Tura Town Church and also the Executive Baptist Church, and also the nearest education institution that is at least more than 300 meters away from the nearest development committee, Walbakri Town Committee. So there are no way, because I
have rule
and also
1832.
I'm relying also the report which filed by the Deputy Commissioner.
See, it from your compilation.
My lord, yes.
Your compilation is amended by Assam 1974, I think.
Yes, yes. There was an amendment made by the Meghalaya in 1983.
Where is that? The one you're showing is amended provision. If it's by reference, you legislate by reference, that means whatever amendments have been Assam Act will automatically apply. But when the corporation, then it will not apply for adaptation. Yes. With regard to the location?
Well, can you have page 4?
Yes.
Here they have substituted the existing rule 191 of the principal rules of the following shall be substituted, namely the opening, shifting, amalgamation and closure of any licensed premise shall be done by the Deputy Commissioner with the previous sanction of the state government. Such opening, shifting, amalgamation and closure shall not be granted unless it has been satisfactorily established by local inquiry that the proposed action is necessary in the interest of public.
What about the distance? Where's the distance?
The distance has not been.
Is there?
With regards to distance, my lord, on the previous order dated 26/03/2026, my lord, they have it is reflected, lordship.
Which order? The order of this court?
Yes, order of this court.
26.
26/03/2026.
Yeah.
26/03/2026. Para 2, my lord. In the para 1, it means like the first para also they have mentioned the rule. As per the Meghalaya Access Act, the distance as per Rule 183 bracket 2A, no IMLP and beer, yes, beer retail of and on license shall be established in any area within the distance of.
On that occasion, we have cases regarding the distance.
Oh, yes, yes. He's not here anymore. You supplied again. Where's Mr. Shulai? We'll close the matter today. Because if you're making a basis, if you're not within 200 meters in the vicinity and you're raising objections by saying that it'll cause harm society, what doesn't cause harm
Can
society?
you have the reports filed by the deputy commissioner as well as the.
We've seen that. We've already seen that. You appeared for the first time, I think, today. Have you appeared earlier in this matter?
No, my lord.
No, yes. You apprise him. What is done? You look at all the order sheets.
Well, yes, I've gone through all the order sheets.
We tear up tomorrow. Yes. You just give that copy to Mr. Sangma also. That location. You have prohibition everywhere. Don't allow bars to run.
No,
you make complaints that
we have
illegal
filed
sales
complaint
going on
against
that
the bar.
area.
We have filed
Yes.
complaint against the bar.
After this case came.
No, but that's why I'm saying that we are not aware of regarding the existence of the bar.
You can't go and bless one bar and close the other one. You might be whatever position you have. That's fine.
All right.
What's your source?
If you want to make a statement to your congregation or community, that's well and good. But the law has law.
We are basically the development
Yes,
committee.
law. Yes, rule of law has prevailed. That's all. Objection to say objection is not really appreciated. Yes. Yes.
My lord, in this matter, the private respondent are yet to file the affidavit.
Some time in lordship to file affidavit, lordship.
Have you filed a joinder to 126?
Your lordship will be needing some more time, your lordship.
Yes, why taking time?
Lordship, 2 weeks time in lordship will give it. 2 weeks time in lordship.
Is there appointment to professor or no?
Post for assistant engineer, lordship. Junior engineer.
Any urgency? No.
No, your lordship.
Yes. 1 week's further time is allowed to respondents 7 to 10 and 12 respond with Mr. Snaitang for affidavit. This thereafter, yes. What?
2 weeks
for the orders, yes. Yes.
24.
Your Lordship, I have filed for amendment of the course title.
Yes.
Yeah.
So the miss case.
Pray for the
miss case.
Miss case 132, Your Lordship.
Yeah. It's number 4.
Did you file objections?
Yes, Your Lordship.
Where's your prayer?
My prayer,
What?
my Lord, an application under rule.
Yes, yes, okay. Which part you want to change?
I want to the course title only.
What is this? What bad custom, Mr. Summer?
Bad custom means that because the husband beat the wife, torture the wife, but he play a victim, and
who played victim?
And the respondent, the husband. So the village court gave an order in favor of the husband, and the subordinate court of district council upheld it, and just district council also upheld. So
no, but your course title you want to change. We could not understand. See, the first, okay, now you see an application under Order 6 of the High Court, okay, you read Consular Court's order for setting aside the bad customs.
Yeah.
How, which is opposed to public policy.
This one.
How can you?
I want to change this course title. An application under Article 226 of the Constitution of India for issuance of writ in the nature of mandamus, certiorari, or any other writ, order, direction of the like nature as Lordship may deem fit, and this. For this one, your Lordship, I wanted to change my prayer or amendment in this miscellaneous 132, 2026. Page 4.
No. The course title, you seem to set aside bad customs. You want to add that to your course title?
Yes, because bad custom, in the sense, it is wrongly interpreted by the subordinate court. In fact, this
we can understand for setting aside any orders passed by any subordinate court or trial court. But can you seek a mandamus?
I am not
for setting aside or quashing bad customs. How we start defining bad customs in this
bad custom
case?
In this particular case, your Lordship, it is everything has given due advantage to the husband.
Just give an example. What happened here? Why you say bad customs? What bad custom was done by the whatever the parties or which has been sanctioned by the village court? What happened?
Because your Lordship, the custom according to Garo customary law, if the wife died, then suppose the clan cannot substitute the husband. In that case, only the property will inherit by the husband. But in this case, the husband is a drunkard, beating, torturing the wife, and the children does not want to live, but the wife become difficult for her to live together. So she refused to live together. That is only the thing.
No, now you are the wife.
Yeah, I am the wife. I am the wife. So my prayer is only.
Let's see the order of the village court. What does it say? No, the prayer is too vague.
I'll see. This village court has recommended.
Where is that?
39 of the writ petition.
39.
39. Translated copy, my Lordship.
Yes.
With due respect and humble submission, we are submitting the inquiry report of the case. We, after seeing the report of the case by Laskar, Sri Venan Sangma, the complainant Sri Genan M. Mara, and the respondent Sri Murti Tenol B. Sangma.
I understand now. Because you refused to accept him back.
Yes.
And so you had to pay 60 rupees.
60 rupees.
That's fine.
Fine.
Along with the property.
Yeah, along with the property. So the wife become outside. She does not have property.
What does the inquiry report say of that Laskar? Where is that here?
It is this one only. Laskar is not separately given.
No. See, after seeing the report of the case by Laskar Sri Venan Sangma, where is that Laskar's report?
This is a report only.
Yes, report, of course. They gave the report. This Laskar did the inquiry. The report was given by these two, whatever jury member, whatever of the Magalpara village court, asking the wife, asking to pay 60 rupees and to part of the property.
Yes.
Along which property?
It is not specified, your Lordship.
Where's the report, Laskar?
Report of the Laskar is not
Available.
given to the wife.
Now, what is the 31? You are Jinan Marak. Who's Jinan Marak? You're the husband.
The husband, Your Lordship.
Yes. Okay. It's really bad custom that way. If without any proper adjudication, you just deprive of your.
In this case, my lord, there are 3-4 property, land also, but which one it is not specified. The wife has suffered a lot. And even now she is being harassed.
Where are these people now?
Your Lordship, initially they have filed this petition under Article 226 against a private person, Your Lordship. Then we have filed, subsequently we had filed an objection to raise a question of maintainability and filed an objection. And they had sought for time to file a reply to a maintainability. Instead, they have filed this dismiss case for amendment, Your Lordship. Now, I have filed my objections to the amendment, Your Lordship. You can just
Mr. Sangma, if you want to make a more comprehensive petition, you'll be advised to withdraw and file it afresh.
I'll discuss with my client.
Yes, again, otherwise your prayer is title is a bit too vague.
Yeah.
And also from the record, if that is the order they have come against, that and this order is upheld by the Sovereign Council Court.
Yes.
all remedies have already been exhausted, Your Lordship.
Already 60 rupees, but already up to the judge.
They have already filed a second appeal, so it was also dismissed, Your Lordship.
There are still bad custom available in the Garo, because men does not have anything. Unmarried goes to the mother, to parent, married to the wife and children, nothing. And in this one, it is the reverse. There is no law to.
Now in this appeal, which was judicial officer, that means but the appeal is
I'm coming under order 6.
Mr. Prosecutor, the appeal that was filed by the wife, 2018. But see what appears that it seems to be a case of domestic violence which has been turned into a divorce matter. Yes,
they have not filed. It went to the police station, but police station or police also didn't take.
Okay, it's at page 56.
Yeah.
Were they married? Do they have a marriage certificate?
Marriage certificate
they were married
also,
legally.
The clan gave her to marry this person, Genang.
She is a substitute wife. This Tinol is a substitute wife.
Substitute wife.
I mean, Genang was married earlier to someone else.
Yes.
She died.
To the mother.
Genang was married to the mother.
Yeah.
Then Tinol gives substitute wife to Tinol, and she refused to stay with him.
Yes.
Okay.
She refused because he tortured, the husband tortured, beaten, even sometimes threatened to kill.
Why did this matter go to the District Session Judge? So one thing, just outside the this property after return, it's your property or belong to the husband?
Property.
It's your property.
My property, ancestor property.
Because fine is here as per customary law of Garus. Then if you commit something, village court has the power to impose any fine. It's called die, you know? Yes.
Not exceeding 50
whatever, not
rupees.
exceeding 50 rupees, whatever. But then with regard to the property, now what happened for village court was a complaint of domestic violence. But he says that it's like for restitution. Correct?
Yes, sir.
And Mr. Sangmaskan refused. So that's why you had to pay die of 60 rupees
60
and
rupees.
have to return the property. Return property means that means return. That means all property means it belongs to him. The property.
Yes.
It belongs to him because he must earn it from the.
Not returned.
It belongs to you.
Yes,
You stamp because
along with property. Along with property. Not
whose
returned.
property is it?
This is ancestor property. My
You
lord.
sure about that?
Yes.
Very complicated matter. But the thing is that the village court decided that they had examined you also.
Examined.
And then there was an
but
inquiry also.
it is,
Even though
not
how
actually-
you know how offensive it might seem, but
It
the
is
village
not
court it might be very offensive. Like whatever order has been passed against you might seem very offensive. But the fact remains that this dispute was brought for village court, and you were examined, and his prayer was that he wanted to cohabit with you again, which you refused. So the village court only on that premise said that fine, since you refuse to take him back, and since she's married to you, then fine, you pay the fine, the die of 60 rupees, and you return the property. So your case now is that village court,
he does not have a property. That is the thing.
he doesn't husband. That's a different issue altogether. So that is where now the property that is what a village court said, right? You give back the property to the respondent and pay the fine.
And which property? What kind of property is not?
No, that you know better. So that is where the whole thing lies. So village court, if you go strictly within the meaning of what village can do, is done what it should do actually, right? In settling the dispute within the village itself. That you refuse to go, that's a proven fact. You've admitted also village court that I don't want to take him back. So it ends there. So it's not a divorce. Also, is not a. It's not what do you call it?
Yeah.
It's just a finding that fine, don't take him back. Pay a fine and give the property back, without any further orders of what you have to do after that. So that's why your property has been taken away. That's why you're aggrieved, and all the courts below have come same finding that the village court had given you an opportunity, and as per Garo Customary law, there's imposition of fine is allowed. And if it's his property, then you have to return to him. Now, whose property? You're saying ancestral, you're saying your property. Whose property is it?
Self-acquired property. Husband's. Ancestral, she cannot claim.
That is what, no, ancestral she cannot claim.
She does
That
not
is
have
what the
an-
property means. What property do you return? Now, after the order of village court, what property do you return to the husband?
In the order of the
No,
village
forget about the
court, they
order.
said along with property, not return.
Apart from the records, if you want to bring like coitus to the matter, now from the records only, already taking a long time this matter, but it's very interesting in the sense that now village courts active. If you look at it's within the jurisdiction, they are the power to settle disputes. They didn't give you a divorce. They said since you refuse to take him back, pay 60 rupees, return his property. Now, what property do you return to him? What do you give him? When the village court gave the order, you gave him back the property, right? Or you didn't give anything?
Till now, we have not given.
But it's not given till now.
But he has taken over
If you're not given to him, he's taken over what now?
All the veterinary and all these things, plantation, they have taken.
Then you have to file a different suit then, because that dispute which you had for the village court does not address the differences you have with the respondent. Because you see, Mr. Samay asking for setting aside bad customs, you see, right? You want to amend the petition. Now, what is a bad custom? What's a good custom? Now, if Garo Customary allows that, to settle dispute even between husband and wife, it's been brought before the village court. This order has been given village court.
Because
you're taking your stand that I don't want him back. So that's it. So he said, okay, fine, pay a fine and return property. What other steps you take that time? It will not be the basic order. Then you have to take other parallel proceedings. You file for divorce. You are Christians, right?
Yes.
Yes. If you are Christian, then you are governed by the Christian Marriage Act or Divorce Act. Then you file for divorce. Then the law takes own course with regard to property. Whatever, yes. By application of customary law there also. But if prima facie, it didn't grant a divorce or anything. Just said pay the fine, returns property.
Yes.
If you don't want to stay with him, that's all.
That's
there. Then how will we interfere? And how will allow your amendment to set aside bad custom? You think about it.
Yeah.
So it's come down to that. You understand that that's the tentative view of the court, that even though it may look very offensive, the order, that maybe he's getting trouble, maybe like she also has issues because she's a substitute wife for you, and you're whatever mistreating her, or that he is mistreating you.
Yes.
But that is,
you seek instruction.
Yes, on this miscase also. Have you filed objection?
Yes, sir.
Yeah, already filed.
The objections are, Mr. Parson, one of the objections have been filed to the application of amendment of the writ petition. So, in the course of hearing, Mr. L.M. Sangma prays him allowed to obtain further instructions. Just after 2 weeks, yes. You see what course action you will take. You have to advise them.
Yes.
25.
Please, Lordship.
Lordship, that's the second contempt we filed today.
Yes, Lordship. It's a similar contempt petition, Lordship. Dear Lordship, I have 3 prayers, Lordship.
Yes.
Lordship, as far as the
affidavit.
Today the petitioner has filed an additional affidavit, Lordship. So I'll file my
I'll be
counter
filing in course of the day, Lordship. I've already served him a copy. As per the last order, Lordship, I'm supposed to file the additional affidavit.
Yes, Mr. Chidakar.
And Lordship, I have one more prayer, Lordship.
Affidavit allowed by this court, by order 26/2026, will be filed in the course of the day.
Lordship, as far as this respondent 2 is concerned, Lordship may strike his name off.
Lordship, they have preferred a separate contempt.
A separate contempt against him has been preferred.
Doesn't matter.
And Lordship may club this.
Yes, list this matter together with
item number 1. Obliged, Lordship.
26.
May it please your Lordship, we will not be filing the rejoinder, your Lordship.
Yes.
We will not be filing the rejoinder and go for the hearing, your Lordship.
One six. MS Hongre.
Yes, your Lordship.
On a petitioner submits that no rejoinder will be necessary. Just for hearing when?
2 weeks, your Lordship.
Yes.
Much obliged, your Lordship.
27.
Please, Your Lordship, as per the last order, Your Lordship had directed us to take steps to find regarding the disputed amount, Your Lordship. After the last order, we have sent an email, Your Lordship, to the concerned authority, like we did earlier also, which is part of the affidavit, Your Lordship. Your Lordship would like to fairly submit, Your Lordship, the writ petition of the at page. Just one like to point it out, Your Lordship. page 27, which is a representation which was submitted by the petitioner to the respondent number 4, and a delivery of which has been delivered. This representation was not replied. In our affidavit, Your Lordship, I had submitted, Your Lordship, that we do not have any objection, because we have also tried our best to get contact, to establish contact with respondent number 4.
This freeze account.
Yes, Your Lordship, because I feel we should fairly submit
Yes,
it, Your
sir.
Lordship.
As Manapan today has fairly submitted that in spite of best efforts, they could not obtain the exact amount which is in dispute with regard to petitioner's account. It submits that as do not get the account, the bank is ready to unfreeze the account of the petitioner. Yes.
So, Your Lordship, the statement, if it can come and record, it's at para number 4 of my affidavit, where I have stated that that we do not have any objection to defreezing the court directs.
In this regard, in addition, submission has referred to
Paragraph number 4 of the affidavit file dated to 2nd June 2026, Lordship.
7 June 2026.
Paragraph 4 of the affidavit, Lordship.
Paragraph 4 of the drawn attention of the former. In addition, submission has also referred to paragraph 4 of the affidavit file on behalf of the respondent number 5.
Lordship.
The same for the same convenience is reproduced here and below. Next paragraph. In view of the concession made by the narrative 5, that is the account of the petitioner being number so and so shall be unfrozen by the respondent 5 within a period of immediately.
At least we need time. 1 week.
One week. The disposal of?
Yes.
Yes.
In view of this development, MS ADC for the place that the matter also will be closed. Matter stands closed and disposal, yes.
28.
Body presence. Yeah.
Bishop, in this matter, they have to file the affidavit. We're waiting for the affidavit. State as well as the respondent. The respondent.
Yes, I can't hear you.
I've just received the signed affidavit, Lordship. I'll be filing now.
Course of the day.
Lordship.
MSEB Passawa report 6.
Yes, sir. Number 6. They have to file.
It's already filed.
They have to file.
Are you filing affidavit or not? What's the matter about?
Lordship, this matter is about pension.
The second wife. Okay, MSEB Passawa for number 5 submits that after we file in the course of the day. What is your name? Mr. Pino for respondent number 6 submits that praise funds allowed for the 2 weeks time to file affidavit. If we file it.
Much obliged.
29.
Respondents are yet to file the affidavit, Your Lordship.
Yes, Lordship. I prefer more time, Your Lordship, to file my affidavit.
What's the matter about?
Payment of gratuity and other benefits. Lordship.
GHDC?
Yes, Your Lordship.
From Bambara? Municipal committee?
Municipal. Your
How much for the time is a day?
Let me kindly grant this. This is for district council, man.
Petitioner has since retired, Your Lordship.
There is a notification which says, my lord, this is the government. After the signing of the pact, my lord, the government will pay the gratuity of the retired employees. That is what we want to take a categorical instruction, my lord. Whether
is that what happened to that?
That is
bailout package.
This is the letter which has been written to.
No, but the government they had a bailout package for the this one.
Yes, 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 my lord.
With regard to the pending dues.
Yes, my lord.
Mr. S. D. to be praised for further 2 weeks' time to file to seek instruction to file affidavit. Submit to the council that in view of the development, in view of the
letter dated
17 March 2026, whereby certain arrangements have been made with the state government to enable payment of pension of retired employees, leave encashment and gratuity of retired employees. The gratuity petitioner will be satisfied from this arrangement. Yes. Because you can escrow account, escrow agreement.
Right.
That means whatever
Yes,
income
ma'am.
you can't touch it.
No. So it will be the state who will give it directly to their account.
Yes.
Your Lordship, if a copy may be given to me.
Please allow us and give it to us.
30.
Respondent 2 and 3 are yet to enter appearance.
Lordship, I am entering appearance on behalf of respondent number 2.
Lordship, we have filed a affidavit in opposition.
What about 3?
She is
served.
Lordship, we will file affidavit of service. Yes, Your Lordship, we were permitted to take step by way of dusty.
They have been served.
Lordship, we will file affidavit of service. Your Lordship.
Wait 2 weeks, Your Lordship, for
MS
filing affidavit.
is Sindram. Available appearance today on behalf of the respondent number 2. Your name? What's the name of this lady?
Eboro.
What is your name? MS Eboro for respondent number 2. Submits 1. Submits application has been filed. So, though it is reported by the Land Council petitioner that the respondent number 3 has since been served, there is no appearance on his behalf today. You have not filed service affidavit also. Yes, service affidavit will be filed.
We will be filing rejoinder to affidavit in position filed by
indicate the
respondent.
fact of service. Petition also put file rejoinder to the affidavit filed as number 1.
Interim may be continuing, Your Lordship.
Interim there?
Lordship.
The interim order will need to continue next year. Yes.
31.
And your right, Lordship.
Wait, please, Your Lordship. Your Lordship, I'm praying for 2 weeks' time to file our affidavit.
What's the matter about?
Your Lordship, it's a matter in regards to appointment in lieu of the land donated by me in favor of the respondent.
For a 2 weeks time, please allow this.
I'll do.
Not pension here. No, sorry.
Lordship, here also we pray for 2 weeks time to file our
Lordship,
affidavit.
regarding the private respondent, my lord, 4 and 5, we have taken step yet to receive the delivery report.
Have return of service? Yes, MS Tiang EB. Then an AG prays for that for a 2 weeks time for affidavit.
Respondents 1 to 3, Your Lordship.
That the notice for 1 to 3 noted that the notice respondent numbers 4 and 5 here, they will complete this after 2 weeks for affidavit and for service report on 4 and 5.
Obliging.
Second call, supplement 5.
Meet preserve.
Yes.
My lord, we have come against the impugn order, page 142, my lord.
Page?
Sorry. Page? 395, my lord.
395?
The last page.
Yes.
This is dated
Yes. Oh no, not this one.
This is dated 9th of June 26, my lord. From Director Distribution, Meghalaya Power Distribution to us, my lord, Sai Computers. It says, my lord, whereas the Meghalaya Power Distribution Corporation issued a letter of award dated 10th November 25 in your favor appointing Sai Computers Limited as distribution franchisee for Motionram subdivision under MPDCL subject to fulfillment of conditions of letter of award. Whereas letter of award under clause 4 provides distribution of franchisee agreement is required to duly executed within 60 days.
Where are you
of
reading from?
Page 395, my lord. The impugned order.
2.
Para 2, my lord.
Yes, yeah.
Whereas the letter of award under clause 4 provides distribution of franchise agreement is required to be duly executed within 60 days of issuance of letter of award. However, despite a lapse of more than 6 months from the issuance of letter of award, no distribution franchise agreement has been executed between MEPDCL and Sai Computers. Whereas the letter of award under clause 6 provides your firm to start the necessary activities for completion of conditions precedent and other necessary conditions as specified in the bid document. So those I can skip, my lord. Para 4, my lord. Whereas even otherwise the letter of award under clause 1 provides the distribution franchise shall be responsible for various activities related to the distribution and supply of electricity in Mosindam subdivision as detailed in the RFP. However, due to the failure to commence effective distribution franchise activity, it has in turn caused commercial losses to MEPDCL. Therefore, no concluded contract has come into existence between the parties and the letter of award has exhausted its validity and purpose. Now, therefore, in light of these circumstances, Meghalaya Power Distribution Corporation, exercising its power under letter of award dated 10 November 25, hereby cancels the letter of award dated 10 November with immediate effect and takes over the operation of distribution and so and so. So, my lord, now, my lord, going to the history of the case, my lord. My lord,
does not mention anything of what about the other factors which
other factors, my lord.
Then,
my lord, most interesting, my lord, kindly see.
Confining it to simply a contractual infringement.
My lord, that's one aspect, my lord.
Then,
second aspect, my lord, kindly see page 393, my lord. It's a complete colorable exercise of power, my lord. This is, lots of you seen the impugn order of 9 June, my lord, and this is the news report of 9 June, my lord. I'll not read the first part, my lord, because there are disturbance from the pressure groups, my lord, right from beginning. CM SEO's termination of contract, my lord, kindly see.
Yes.
Lots of you seen. NPP leaders from 3 blocks, Chief Minister.
You can't take cognizance of this, Dr. Mehra.
My lord, just for the purpose of indicating that this is a colorable exercise of power, my lord, because it is.
This is the.
Let him submit. Yes.
NPP leaders from 3 blocks claim Chief Minister Conrad K. Sharma has assured that the power distribution contract awarded to Sai Computers Limited for the Mosindam division will be terminated. The assurance followed representation from party leaders in Mosindam, Mauflang and Ranikor who reported public outcry over sharp increases in electricity bills since the firm took over distribution for the Meghalaya Energy Corporation Limited, so and so. Former Mosindam MLA Hima Sangkliang told reporters that the delegation.
We can't take cognizance of this.
My lord, to show, my lord.
Political parties can make any statements. How?
My lord, kindly see the sequence, my lord. 9th, this statement is made, my lord. And not only this, my lord, I'll show from the affidavit filed by MEPDCL and from headman of Mosindam in the other writ petition, my lord, that the issue is something else, my lord. Because earlier people were used to, for many years, my lord, not paying the electricity bills. Now because of the new system, my lord, there may be some increase in the electricity bills, and because of that, there was some protest, my lord. So, the second aspect, my lord. Third aspect, my lord, what you have seen, the LOA provides for signing of agreement, my lord, within 60 days. I'll just take a lordship of the particular clause, my lord. Is 144.
What is the situation on the ground now?
Since
who's looking after distribution? Because see, in the
they are not collecting.
In the end, is the consumers. I mean, the villagers there. Suppose this fight between you and the MPDCL will cause, disruption in power supply, and that's only the cost consideration for interim orders to be granted or not allowed. That's what you think.
They have not been able to do
just one
award of the contract, my lord. So we are MEPDCL is not able to.
Yeah, Mr. Ravi Journalist, let him submit. You'll have your turn.
Kindly come to page 144, madam. In fact, from page 142, madam, this is the letter of award.
Excuse me. Yes.
But this letter of award dated 10th November. By this, the letter of award is given, my lord. Kindly see page 144, my lord, clause 4.
145.
At page 144.
140?
144, clause 4.
Yes.
Execution of distribution franchise agreement, my lord. Now, lords, you've seen this LOA is dated 10th November 25. So 60 days expired on 10th of January 26, my lord.
1 second. The date of commencement of work, effective date 1st November 2025.
Yes, ma'am.
Then?
It says, my lord,
when was the LOA issued?
LOA is dated 10th 11, my lord. Page 142 also, 10th November.
Okay, LOA is 10 November.
Work to commence from 1st of December. Effective date is 1st November, my lord.
Yes. Yes, so 60 days will be.
Even if you count from date of LOA, my lord, it will be 10th of January 26.
Yes.
Now it says, my lord, you are also required to sign the DFA duly executed by the authorized signatory within 60 days of issue of this LOA on a non-judicial stamp paper.
Yes.
This 60 days expired on 10th of January, my lord.
Yes.
Now, my lord, one important aspect, my lord, the same petitioner company is awarded the same work, my lord, in 4 electricity subdivisions in Meghalaya, my lord. I have annexed all the documents. Mausindram is one of them. The others are Dalu, Nangal Bibra and Fulbody, my lord. For others, because we were able to get the trading license from Garhwal District Council, my lord, so we have signed the DFA within time with same MPTCL, my lord. Only because there was issues with from getting the trading license from district council.
License now.
Well, we don't have till now because the matter is pending. Your notice is past interim order, and in that writ petition, MPTCL is a party, and there are directions by this honourable court to allow us to continue, my lord, and that order is binding equally on MPTCL also, my lord. Without taking any leave from your lordship, they've taken this action.
Yes.
Page.
This is dated 10 November.
10th November last year.
This is the letter of award for appointment.
Yes. 60 days you are required. So 60 days expired on 10th of January 26, my lord. Because they are aware, my lord, the difficulty faced by us. They filed their counter affidavit in the other writ petition, my lord. I'll take your lordship to the other affidavit. What is the stand of MPTCL in that?
So by one letter, they gave franchisee for you in Mausandra, Nangal Bibra, Fulbari.
Yes, my lord.
3 places.
3 places.
Okay.
Now other places are in Garhwal, my lord. We have trading license from Garhwal District Council, and we signed the agreement, and we are operating those till now, my lord. Remaining 3 more, my lord. Dalu also is there, my lord.
Yes.
Now, the MPTCL is well aware, my lord. Well aware, my lord.
You're going to sign the
LOA because of non-issuance of trading license, my lord. Matter is sub judice pending before your lordship. Lordship passed effective orders in that. In the meantime, my lord, because of public pressure, even in the affidavit filed by Headman Mausindram in the other writ petition, my lord, the issue has been very vividly described by them that it is the dispute is because of overbilling, my lord.
Yes.
Now suddenly, my lord, without issuing any notice, absolutely nothing, my lord.
To report your performance.
Well, that is why I was indicating the news report also, my lord. News reports on that day, same evening, my lord, letter of termination is issued. No notice, because if they give a notice, we will clarify to them that these are the issues, we are not able to sign the DFA because of trading license issues, and which is pending before your lordship, my lord. Effective orders have been passed in that manner.
Yes.
And my lord, in the RFP there is a complete mechanism for termination, my lord. I'll just take your lordship to that, my lord. Page 120, my lord. Page 120, my lord.
Termination procedure.
Termination procedure, my lord. Termination procedure for event of default by distribution franchisee. Well, there are both. 16.4 deals with default by MPTCL, my lord. 16.3 deals with default by us, my lord. I'll read, my lord. 16.3.1. On occurrence of any event of default or its coming to notice of MEPTCL, MEPTCL shall issue an event of default notice to the distribution franchisee. The distribution franchisee eliminate, mitigate consequences of such event of default within a period of 15 days or event of default cited under so and so, so and so. In case the distribution franchisee unable to eliminate, mitigate the consequences of event of default within period stipulated so and so, a preliminary notice of termination may be served by MEPTCL to the distribution franchisee elaborating event of default by distribution franchisee. If the default is not cured within a period of 30 days from the date of issue, the preliminary notice of termination as provided in article so and so, this agreement may be terminated after serving the final termination notice. My lord, the 3-stage notices are provided under the contract, my lord.
Yes.
So, my lord, and in this case, my lord, there is not a single notice, no opportunity to us to explain our, and they are well within know, my lord, why we have not been able to sign the DFA, my lord. Because of non-issuance of trading license, that is the only issue, my lord. And our bona fide is indicated, my lord, because in the other franchisee, my lord, within Meghalaya, with the same MEPTCL, my lord, we have signed the contract. And there is no complaint whatsoever of any nature in the other franchise, my lord. So, my lord, in my humble submission, this is absolutely colorable excess of power, my lord.
Coming back to next question, what will happen on the situation on the ground if they say that they've taken over the operation?
My lord, this we received on 11th, my lord. Though this is dated 9th, page 394, your lords will see.
Yes.
11/6. We received this on mail. We filed it yesterday, my lord. Today we are on 17th.
Yes, Mr. Advocate General.
My lord, we have invested a lot of money. My lord, if I can explain what is the nature of business here, my lord. My lord, if we take example, the entire Shillong, my lord. Now, earlier MEPTCL set up their own meters. They go house to house, read the meters, raise the bills, and consumers have to pay the bills. Now, here under the new system, my lord, there is a central meter somewhere installed, my lord. MEPTCL supplies power till that point, till the central meter only. And we pay MEPTCL on the consumption indicated in the central meter, my lord. Internal billing, my lord, within Shillong town, house to house, and maintenance of wiring, maintenance of everything is for us, my lord. So we have to invest in setting up transformers, wiring lines.
Yes.
We have to invest.
There is no such statement in the entire writ petition, my lord. Not a single government, my lord.
No,
But my friend is saying everything.
The thing is that
Yes,
it's just explaining. No, it's explaining how the system works. Now the thing is that
no, my lord, that is not correct.
The supply.
That is
Okay,
not, that is
no,
also not
just
correct,
one
my
second.
lord.
Just a clarification. Yes. Now the power comes to your company, right? You're stationed there.
Yes.
So you have a sort of substation or something. Then
We are using their substations, my lord.
Yeah, of course,
but there is a central meter, my lord. My lord, if I can just simplify, in High Court building, my lord, there are 10 rooms and there are 10 rooms have to pay individually their bills, my lord. There is one central meter somewhere. Now this company pays the billing as per the central meter to MEPTCL. There is a tender for that. We are the highest bidder for that, my lord. And now, at what rate will bill the consumers, my lord? Those are notified by MSARC. It is not for us.
Yes, for you also.
It is not for us, my lord, at what rate to bill.
Price, yes.
Do the billing. Below poverty line, there are separate billing. Slab wise, there are separate billings, my lord.
Okay.
And we have to follow the same schedule of billing for the entire state, my lord.
So the distribution system is in place.
Distribution system.
Whoever comes, steps anybody's shoe. Suppose
yes, my lord.
A is gone, B comes.
B comes, my lord.
The things.
Lord, earlier also there was another contractor, my lord. We entered into this contract only in the month of November, my lord. You have seen.
What investment have you done then? You're saying investment.
How much investment is done?
What investment have you done? If that things, the grids already.
Nothing.
I mean, then.
No, my lord. We have set up transformers, my lord. They are very.
No, nothing. Transformer is mine.
No, wait 1 second. Let him finish. I want to know because they're saying that it cause loss is going to cause.
Yes, my lord.
It's abrupt.
And not only that, my lord.
Now you're saying that how much have you invested in money terms?
My lord, we have stated that.
If my friend can show from RFP, at least from RFP document is there.
My lord, the projected revenue for us for next, this is a 10-year contract, my lord, is 173 crore that we have stated in our petition, my lord.
That's a profit, net profit.
Total revenue, my lord.
Gross, net everything.
Total revenue, and out of that we have to pay our employees, my lord. We have to pay MEPTCL bills, my lord.
The power charges from there only.
From there.
It's 10% be a profit.
It's not even 10%.
So anyway, so we can't, yes, let's hear.
So my lord, my twofold submission, my lord, in this case, threefold in fact. No procedure as investors and the contract.
That is clear, yes.
No so-called notice. and it is purely colorable exercise of power when this honorable court is in cessation of the other connected matter, non-issuance of trading license.
Yes, yes, Mr. Arvind.
Yes, my lord. My lord, first point which Dr. Mujka has raised, that no notice has been issued under the contract. That is the first point, my lord, which has been.
Yes.
Dr. Mujka has not pointed out that he has not signed the contract yet till today.
They have been signed till today.
Contract is not signed because of trading license.
60 days. I'm now, Dr. Mujka, please let me explain.
No, the court is asking a question, I'm replying to that.
Yes, yes.
Letter of acceptance, my lord, says that agreement has to be signed within a period of 6 months. That your lordship has seen in clause 4.
No, one thing, Mr. President, yes. Now, if no letter of acceptance has been signed, how did they commence operations then? On what basis?
Yes, my lord. Now that is
what governs and what governs the like, you know, the what juristic kind of arrangement with the then?
Yes, your lordship. I kindly come to page 142, my lord. Kindly come to page 142, letter of acceptance.
Yes.
Now your lordship will find a scope of work, clause 1, my lord. The distribution franchisees shall be responsible for various activities related to distribution and supply of electricity in Mansiram, Nangalbira and Fulbari subdivision as detailed here in RFP document. Now these are the revenue figures which we will get it, my lord. Now kindly see paragraph 3, clause 3 and 4, my lord. 4 is important clause which both of us are relying on, my lord. Execution of distribution franchisee agreement. Yes. You are also requested to sign this distribution franchise DFA duly executed by authorized signatory within 60 days of issue of LOA on a non-judicial duly sealed authorized by each of the page, etc. Date of commencement effective date shall be 1st November. Further, this LOA, you are requested to start the necessary activity for completion of conditions precedent for other necessary condition as required in bid document signing of the distribution franchise. So LOA gives them right to start the commence the operation, meet the other conditions. 7, please acknowledge the receipt and send 1 copy of letter of acceptance. Now last line, my lord, 145 last line. Failure to comply with any of the above requirement listed out at point number 3 and above may result in cancellation of this LOA and annulment of award and forfeiture of earnest money deposit as per terms of RFP, my lord. So this LOA contemplated signing of DFA within a period of 60 days. This LOA required the parties to give the consent, my lord. The petitioner has given consent that if he is unable to complete the DFA within 60 days, it gives me right to terminate the contract. That is one part. And the clause which my friend has shown to your lordship, that 16, has not been signed yet, my lord. This clause has not been signed, 16.3. So what governs the relationship between the parties, in my humble submission, is the letter of acceptance, LOA. So therefore, my friend's reliance on those notices are not misplaced and misconceived, in my humble submission. This is one aspect of the matter. Second aspect of the matter is that, my lord, the LOA, the termination order at page 395, lordship has seen, is in terms of the provisions of LOA, my lord. Because LOA is in place, your lordship has already seen that it is, kindly see once again with me, my lord, page 395. And clause 2, my lord, we are not against this company, my lord. We have permitted, we have signed the DFA with other places, but whereas a letter of award under clause 4 provides distribution of franchisee agreement is required to be duly executed within 60 days for issuance of letter of award. However, despite lapse of more than 6 months from the issuance of letter, no distribution franchisee agreement has been executed between Meghalaya and Sai Computers Limited. That is one requirement. 3, whereas letter of award under clause 6 provides that you form to start necessary activities for completion of conditions precedent and necessary conditions as specified in the bid document for signing of distribution franchise agreement. Our condition precedent and other necessary conditions specified in bid document have not been completed for signing of distribution agreement. Whereas even otherwise, letter of award clause 1 provides that distribution franchisees shall be responsible for various activities, distribution, supply, electricity, and Mansiram as detailed in RFP. However, due to failure to commence effective distribution franchise, it has caused commercial losses to MEPDCL. My lord, as on today, they are not able, and we are supplying the electricity, they are not able to operate. The distribution DFA has not been signed. So ultimately, we are suffering the losses, my lord, and their admission, your lordship will notice at paragraph 12 and 13 at page 21 in the petition, my lord. Paragraph 11 at page 12, my lord, that the petitioner states that.
1 second. Yes.
Petitioner states that on 3rd November 2025, MEPDCL formally handed over Mansiram division in presence of so-and-so for maintenance operation. So their job is to maintain, my lord, and billing and collection operation, and their job is to billing and collection without any complaint. Contract 10 years, etc. My lord. Now kindly come to page 13, paragraph 12.
Yes.
The petitioner states surprisingly sometime last week on November. My lord, your lordship, they have the 1 month. Some members of pressure group under the leadership of headman objected to operation and without any trade license thereafter meeting, etc. So, my lord, one of the conditions was trading license, etc. They did not obtain. They started collecting. Issue was started, which is subject matter of your lordship's consideration in the other petition, my lord. Now, maintenance and collection is not taking place admittedly from their own case, my lord. Now, if your lordship will see the fact of the case, my lord, that it is a terminable agreement, my lord. And under a specific relief act, my lord, there is a clear injunction bar, my lord. If I can take your lordship to the 2 provisions of specific relief act, section 14, my lord, and section 41 HA, my lord. A specific relief act, your lordship may have. Section 14, my lord. The following contracts cannot be specifically enforced. The lordship has section 14, my lord.
Yes.
The following contracts cannot be specifically enforced. And my lord, D is a contract which is in its nature determinable. So what my friend is asking for enforcement of a contract which is determinable. One more provision your lordship has, 41 HA, which was amended and brought in a specific relief act, my lord. Your lordship has section 41, and your lordship first see subsection E.
Yes.
To prevent the breach of contract, the performance of which would not be specifically enforced, my lord. What my friend is saying that there is a breach of contract, and that breach cannot be enforced. Your lordship has seen in 14. And HA, my lord, is a very important provision. If it would, an injunction cannot be granted, my lord. Your lordship has noticed at the beginning, 41 injunction when refused. Injunction cannot be granted if it would impede
that
or
is
delay the
consideration.
progress of.
I think there is a matter concerning the supply of services. That means notwithstanding whatever facts around the case, if you know the situation, if by virtue of orders of this court, it might create a disruption, then that will. That even though they are, made out a case for interim protection, but even then.
My lord, why I am only arguing interim protection, my lord. I am only arguing HA, my lord. Kindly read, bear with me for 2 minutes, my lord. HA says that delay the progress of completion of any infrastructure or interfere continued provision of relevant facility related services being subject matter of the project. And HA schedule is there, my lord. Kindly see schedule next. Electricity is one of the schedule where the law Parliament has said that injunction HA lordship will be signed. See the schedule, my lord. Second is energy, my lord. The electricity generation, transmission, distribution is one of them where injunction is to be refused. Law says that injunction. What my friend is asking for, injuncting us from
That's only
giving effect
consideration.
to the order. Yes,
That's the only
that,
thing.
and therefore my submission is, first submission is, my lord, my first submission is that we have terminated the contract or the LOA, not contract, LOA in terms of provisions of LOA. Second, my lord, your lordship holds, assuming your lordship holds that this termination is not valid, my friend is at best entitled to damages because he is entitled to damages loss which it has been caused to him after whether loss is on my part or fault is on my part or on the part of the petitioner, my lord. That too after determination. Third is that there is a statutory bar in enforcement of a determinable contract. There is a statutory bar on this. And fifth, my lord, if lordship will see balance of convenience also, my lord, as on today they are not in and our electricity is getting supplied, my lord. We have to collect money and we have to give it to the
No, that's
the
only
power
consideration.
generating
Apart from all legal submissions, whatever facts.
Yes, my lord, that
it
your
involves
lordship
services,
will file
and if
counter.
services gets
We'll file
disrupted,
counter
then
affidavit.
let them file
We'll
without
file
hearing
detailed
it.
counter affidavit. Detailed counter affidavit.
So you're already effectively you're not doing anything now there.
Yes.
Effectively been ousted.
Yes, they have been ousted.
Since 11th,
That is the report which we have from.
Since 11th, we are not on the ground.
Then there's no question interims, you know. It involves services.
I'm grateful.
Yes,
My lord,
Dr.
my lord, I'll play something different, my lord. Lordship was protect us from the termination. Maybe not reinstate us in the contract.
Termination has already taken place. Termination has already taken place.
No,
Protect the termination, my lord. The termination is a subject outcome of the petition, my lord.
But you're making it for colorable exercise of power.
Absolutely.
That is what I understand that also. That will take into consideration. The thing is that it's not a question of it's not a one standing here. The thing is that there are other proceedings which is before this court also, which has been taken notice of and orders have been passed. So that also will take into consideration in whether we can
another aspect, my lord, 60 days. If it is so binding, my lord, expired on 10th of January, my lord.
No, that you already submitted that, yes.
So there's an element of waiver and acquiescence on their part.
Dr. N. Senior Counsel with Mr. M.L. Nongpur for the petitioner. Issue notice, Learned Advocate General with Mr. Andy Shulai also.
Lordship, I will be appearing for 1 and 2, your lordship. 1 and 2, your lordship. And Mr.
Iban Sara Simle. Amit Kumar
yes, Leonard AG with MS Iban Saras Imli. Yes, is present on behalf of respondents number.
Myself for 1 and 2, your lordship, along with Miss Nogandri.
3 and 4, and Mr. Andy Shulai.
For 1 and 2, your lordship.
On behalf of 1 and 2, there is no further notice on the respondents. Stop the grievance of the writ petitioner company as set on the writ petition is with the cancellation of
LOA,
the distribution agreement.
LOA. No, agreement is not signed, LOA only. Agreement is not signed.
Cancellation of letter of award dated 10th November 2025 for appointment as input-based distribution franchisee in Mawson Ram subdivision under MEPDCL. Stop. Dr. N. Mozikar, Learned Senior Counsel, has submitted that the ground set out in the impugned letter of cancellation is basically due to the
is culpable exercise.
Is an act of been attributed to the fact that the agreement, what's the agreement?
Distribution franchisee agreement.
The agreement could not be signed or was not signed within 60 days after the issuance of the letter of award, Leonard Senior Counsel submits that the fact that the said agreement could not be executed is already seized by this court in WBC number
67 or
67
or 26.
2026.
And as such, this cannot be a valid ground for cancellation of letter of award. He therefore prays that the prayer for interim stay of the letter dated 9 June 2026 that it will be considered. Learned Advocate General.
But only one more submission.
Yes.
I'm just interrupting a minute. Your Lordship's earlier ordained the other 8%. I just omitted to. Can I just place that order? There's specific direction.
Yes, referred already seized by this court in RPC number
67 of 2026.
Where interim orders are operating.
They are also party there.
He therefore submits that the action of the respondents is vitiated. No, this is what I thought. Yes, he prays for so. Yes, sir. Learned Advocate General, on behalf of the respondents 3 and 4, has submitted that the cancellation was occasioned due to what you're saying, due to the non-fulfillment of the conditions of the LOA, apart from other considerations. He, however, has resisted the prayer for any interim orders in view of the fact that the subject matter in question involves the distribution of essential service to consumers situated in the area. To buttress his arguments, Leonard AG has submitted that I thought that he, however, prays without to put in objection an affidavit before the next date. So this court has on hearing and consult of parties and also on examination on hearing of parties and examination in order notes that the commencement was from 11 November. Well, my note notes that the LEA, the effective date is 1st of November 2025 as per the LOA dated
10/11.
10/11
10 November
2025, and as such the 60 days time would have expired on 10/1/26. Be as it may, on the prayer for be as it may, as the matter concerns the supply of essential services, that is, let's see, and as the respondent 3 and 4 since taken over the operations, most the orders are no interim orders are warranted at this stage, as the same might cause disruption in supply of essential some supply of essential service. So when will we list it? We can dispose of it.
I'm here.
This is matter.
I'll tomorrow also again.
For affidavits when?
After
Yeah,
3 weeks.
you're muted.
Maybe after 3 weeks, Your Lordship. After 3 weeks.
After 3 weeks.
After 3 weeks.
3 weeks, if they take longer, they'll create more complication.
2 weeks, yes.
No, because that nothing.
In the file within 2 weeks.
3 weeks, Your Lordship.
The termination will be subject to outcome.
Yes, the termination.
In any case, all
Because see, making out a case of is a different
that
case.
much observation
If you confine it, then it'll become totally in the realm of private law. So that
Yes,
also
sir. Only that much, my lord. Only that much, my lord.
But if you're going to allege illegality
But this
or
is only till the disposal. That's will be subject to outcome. We will also ultimately dismiss my writ petition. That interim will go also.
That is the thing.
File.
Only that much, my lord.
Yes, sir. This is provided that the termination of the arrangement shall also be subject to the result of the petition. Yes.
Apply, Your Lord.
Hearing. Statement 8.
This matter was heard on the last occasion, right?
Reply.
In fact,
How long will it take?
I don't take much money. Before 1 I think.
Yes.
But my lord, only one thing, my lord. But one aspect I must highlight. There is one more matter, my lord. Because here what happened, my lord, under the old act, there was a provision of appeal under section 39, my lord. These matters, because of the discourse of the then Chief Justice, my lord, the original section 17 and 30 applications were placed before the district judge, my lord. So that's why we could file an appeal before this honorable court, my lord, because one appeal is provided under that, under section 39. Otherwise, the original application goes to assistant to DC, my lord, appeal goes to district judge. Connected matter, my lord, same order has been passed, those we have to file, they have
Commercial
filed.
court.
Because there, my lord,
It's gone to commercial court there.
decree was passed by trial court, my lord, assistant to DC in other matter. First appeal, section 39 appeal was decided by district judge, my lord. More or less common order, my lord, in these matters and those matters. Now they filed a revision against that order, my lord, and that is pending before court number 4. So
That
this
is okay. That doesn't affect it.
No, but we're coming to substantial is a point in law
Same
with
issue.
regard
Yes,
to the
ma'am. So their
EBC
condonation
period.
is there, madam.
Now tentative view of the court after examining maybe will not be entitled to that interest upon interest.
Well, I will satisfy your lordship.
That's the only thing. I mean,
What my
so because the new act, fine, you know, but then if B, the clarification, you agree with the clarification given by the what's the lower court here? Is that commercial court?
Additional deputy commissioner.
Additional deputy commissioner, yes. Yes.
My lord, I will reply after my learned friend completes his argument, my lord. The position of law, what he has placed is not that, my lord. Have you finished? You complete your argument? Yes. Once you finish, I reserve my right to
Of
reply.
course.
Yeah.
Who can shut you down? You can't. You'll be allowed to make a reply.
Yes, ma'am.
Yes. Yes.
So my lord, on last occasion I have given a handwritten one-page note, my lord.
Yes. Because the only thing is that before, because it has been an order of the court, so from the date of
Decree.
award, date of decree,
Yes,
that's the only thing whether you'd be entitled to any relief for that period. Suppose it takes 10, 15, 20 years.
Yes.
My lord.
Before to implement the
Award
award,
rule
you
of
have
the
to
court,
go to the court to get an order from the court to make award to a decree. Correct? Yes.
I didn't get.
See, date of award, from the award to a decree, how much time is taken here? 2 years, 15 years, 20 years.
My lord, cause of action 94, my lord, date of award is 2003.
94. Because why? See, the thing is that from last arguments, the awarded amount was 19 lakhs, correct? 19 lakhs?
Yes, my lord.
As per the note, 19 lakhs so and so. But by the time it's come now, you deposit how much?
2.5 crore.
2.5 crores.
That is not the
Okay, fine.
Yes.
No, that's just,
Yes.
it's just like, it's what we're
Okay.
seeing on the surface. So the thing is that why this happens is because under the old act, that we have an award, you have to go for the court to make it to get a decree, correct? So that is the only thing we have to decide. Now that B period, from the date of award to date of decree, whether you're entitled to that amount, interest upon interest, that's the only thing.
Yes.
You are saying you're entitled to it. He's saying no. So that's the only simple
Yes,
question.
and
Right?
that is the law is very clear. Supreme
Yeah, so
Court
that-
judgment
that
is very
is
clear.
that-
It is from the
why does court saying that we'll confine it to that?
Yes,
Only
ma'am.
for that. For A period, from the cause of action to date award, no issue. From date of decree to actual payment, no issue. Right?
From date of decree to actual payment, that interest is within the discretion of the court.
Yes,
What
date of
court has
date of
granted.
decree to actual payment, that arbitration of the court.
Yes.
Now, what you see, only thing in the question now from date of award to date of decree.
Date of decree.
That's what.
Now, there
we'll
is no
confine-
dispute.
We'll confine,
My lord, only
no,
thing.
we'll confine your
Only to that.
arguments
Yes.
only to that part.
Yes, my lord.
So we have A, B, C. A is cause of action to date of award, right? Cause of action to date of award.
So there is no
my
question
lord,
of compounding, my lord.
That the 3 periods.
Three periods.
Yeah, 3 periods is
cause
pre-reference.
Cause of action to date of award. We
To
take it
date
one
of
period.
reference, my lord.
Or date of reference to date of award. Okay.
Yes.
Okay. Date of reference to date of
Pre-reference
award.
is cause of action till date of reference.
Okay.
That is A.
Okay.
Now, from date of reference, from the time the arbitrator enters into reference,
Into date of
from
award.
there till date of award, that is pendent light.
Okay, yes.
Now, from the date of award till date of decree,
Yes.
that is post award. And from date of decree, it is the discretion of the court under section 29,
We
34.
concern
what
only,
court will do.
only with that
Now
date of
we are-
award to date of decree.
Yes, now
We couldn't find
that is also, they are not disputing that arbitrator do not have the power. Now, it is a settled position of law, your lordship, that arbitrator has jurisdiction and the power to give interest for both, for all the 3 periods, pre-reference, pendent light and post-award interest. Now, it is not their case that arbitrator do not have the power to grant interest for the post-award period. That is from the date of the award till date of the decree. Only issue is that interest, whether he can give only on the principal amount or principal plus A plus B.
Right.
That is the only issue.
That's the issue.
Now, if my learned friends has completed, then I will reply or I will reply.
Yes, yes, you reply.
You don't want me to submit.
No, let him complete, then I will satisfy your lordship. What is the actual situation and the law?
Because tentatively, I don't know. Yes. So that situation
Well, look here,
is not
because-
there under the new act.
But
That's what.
because the amount is big, that is why it is catching ki how it is they are failing.
Exactly.
They are failing. But we cannot go against the law, my lord.
If
What
the
is a
award
settled law? We
if
cannot
the
go.
awarded amount is 19
Yes.
lakhs, and now they're required to pay how much total amount?
250 we deposited, my lord.
2.5 crore
2.5 crore. Now again, they are not happy with that. They file another execution petition, sending bailiff
My
to
lord,
log-
here just
chief
because
engineer's court, my
at
lord,
whose
office.
fault? This is the point, my lord. Every case, in every arbitration case, I argue before the court because it is because of the laches on the part of the department. It is a different matter that my client is getting a huge amount of money where he was entitled earlier. But it is why it has happened because the department is taking the matters very casually, my lord.
No, you are beneficiary of that. Why you are?
I am beneficiary, but it is a public money. They also have to act responsibly, my lord. Now, because the figure has become big, now they are becoming very lucky. From 19 lakhs, you are getting 2 crores. How can it be? But who's responsible for it? You allowed it to happen.
Okay, fine. I want to be okay. That's attracted attention of the court. But whether the
And my lord, that period was not long earlier.
Yes,
Now that period
whether
will not
this
be long.
amount now
Yes.
is what do you call it sustainable according to him.
Yes, my lord. I will satisfy your lordship.
Right. Okay.
I'll satisfy your lordship with the case laws.
Yes.
So, my lord, I pointed out in the chart of the 3 periods, my lord. Now here, because there can be A can be again divided into pendent light and pre-reference, my lord. But to simplify the matter, there is only one cause of action till the date of award. Cause of action was 5/10/94, date of award 5/9/23. There was an award of 2017, but that was set aside by this honorable court, my lord. Matter was sent back to, so effective date of rule of court or date of decree is 9/6/25, my lord, and subsequent period. Now I pointed out, my lord, GC Roy's case, which is in fact cited by them, Constitution bench decision, which says that though there is no provision under the Arbitration Act, and even if there is no provision in the contract for grant of first period's interest, my lord, the learned arbitrator has the power to grant interest, my lord.
GC Roy refers to section 34.
Yes, ma'am. That's section 34 of CPC. So GC Roy said, my lord, even if there is no provision under the Arbitration Act, arbitrator has the power to grant interest for the first period.
Under section 31, all Arbitration Act.
No, section 34 of CPC, my lord.
No, 31, no. No provision in the new act is there.
In the new act, there are
There's section 31, the new act, correct?
Yes, ma'am.
Yes. No.
31(7).
90. Section 30?
31 subsection 7, my lord.
Yes. 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 Okay, continue.
So, my lord, GC Roy, first period, my lord, GC Roy provides for interest, arbitrator can award interest, and the arbitrator is awarded interest, my lord. Though we are agreed by the rate of interest, my lord, but we are not challenging the power or competence of the arbitrator.
12%.
12%. 12% for the
12%.
first period, yes, my lord.
First period, okay, you say from, but the reference, okay, cause of action, did a reference to date of award, 1 period.
1 period, my lord. 12% is an award period.
Pre-reference will be from the date of cause of action till reference, my lord. That is pre-reference. From the date of cause of action till the arbitrator enters into reference. That is pre-reference, that is first period. Then once arbitrator enters into reference and then the proceeding goes on and he passes the award. That is pending till light. That is second part. He passes the award. So pre-reference and pending till light. These are the 2 periods.
Yes.
After he passes the award, then till date of the decree or realization, that is post-award.
Yes.
These are the 3 periods.
Yes.
Pre-reference, pending till light and post.
That is because of your knowledge, but our award doesn't say anything. I can just point out that.
Okay.
So we do not need to go into that much now.
I will show what the award says, my lord. That's what the award says.
Yes.
Now for the second period, my lord, from the date of award to date of decree, the arbitrator himself granted 15% interest, my lord.
Did of award or did of decree?
Yes, my lord.
Yes. 15%.
Yes, my lord.
Yes.
Now for the third period, my lord, I was referring to section 29 of the Arbitration Act 1940.
1940 Act. 1940 Act. 96.
But I have a printout, my lord.
I think it's no, it's here. I think we have a copy here. Yes.
Section 29 reads, my lord, where and insofar as an award is for payment of money, the court may in the decree order interest from the date of the decree, at such rate as the court deems reasonable to be paid on the principal sum adjudged by the award and confirmed by the decree. So my emphasis on the phrase, my lord, principal sum.
The court may decree order interest. Or did it keep such rate deemed to be principal? Yes.
On the principal sum, my lord.
Yes. Yes. Noted. Yes.
So because the principal sum in the award is 19 lakh rupees, my lord.
Yes.
So post decree, that is from 25 onwards, can also only be on the principals on the 19 lakh only, my lord. So lordship, I pointed out 3 stages, my lord. First stage, section 34 of CPC itself says on the principal sum.
Yes.
Should I place once again section 34?
Yes.
It says, wording is more or less similar as to 29 of Arbitration Act. Where and insofar as decrees for payment of money, the court may, in the decree, order interest at such rate as the court deems reasonable to be paid on the principal sum adjudged.
Yes. Yes.
So, my lord, for 3 periods, my lord.
From cause of action, date of the suit to the decree.
So, my lord, to say, my lord, that for first period interest will be on principal sum adjudged. For third period, interest will be on principal sum adjudged. But for second period, my lord, it will be on the compound interest. In my humble submission is absolutely inconsistent, incoherent submission, my lord. That cannot be, my lord.
Yes. Yes.
Because, my lord, the Hyder Consulting decision which came in as a decision,
Yes.
2015 judgment, whether this was interpreting section 31.
No, I have this.
This judgment interpreted section 31(7), my lord.
55. Para 56.
There are different opinions, my lord.
They're cited by.
Yes. Because in this matter, my lord, this was a 3-judge bench, but the decision is 2:1, my lord. Justice Dattu dissented, my lord. But I'll read the majority opinion, my lord. Justice Bobde and Justice Sapre concurring, Dattu, Chief Justice dissenting, my lord. I'll read from para 3, my lord. I'll read few paragraphs of this one.
Para
3, my lord. Page 200, my lord. Because majority opinion is very short, my lord. Dissenting opinion is longer in this.
Just that to help that interest upon interest is permissible. Correct? Yes, reading from para 3, read, yes.
Subsection 7 of section 31 of the Act, which deals with the power of the arbitral tribunal to award interest, reads as follows. 31(7)(a), unless otherwise agreed by the parties, where and insofar as an arbitral award is for payment of money, the arbitral tribunal may include in the sum for which the award is made interest at such rate as it deems reasonable on the whole or any part of the money for the whole or any part of the period between the date on which the cause of action arose and the date on which the award is made. A sum directed to be paid by an arbitral award sale, unless the award otherwise carry interest at the rate of 18% per annum from the date of award to the date of payment. Clause A of subsection 7 provides that where an award is made for the payment of money, the arbitral tribunal may include interest in the sum for which an award is made. In plain terms, the provision confers a power upon the arbitral tribunal while making an award for payment of money to include interest in the sum for which the award is made on either the whole or any part of the money and for the whole or any part of the period for the entire pre-award period between the date on which the cause of action arose and the date on which the award is made. To put it differently, subsection 7A contemplates that an award inclusive of interest for the pre-award period for the entire amount directed to be paid or part thereof may be passed. The sum awarded may be the principal amount at such interest as the arbitral tribunal deems fit. If no interest is awarded, the sum comprises only the principal. The significant words occurring in clause A of subsection 7 of 31 of the Act are inverted, the sum for which the award is made. On a plain reading, this expression refers to the total amount or sum for the payment which the award is made. Parliament has not added a qualifying like principal to the word sum, which in our case is, my lord. And therefore, the word sum here simply means a particular amount of money in section.
Interpreting this new Act M37.
It's a new Act, my lord.
Yes, and so you said that sum will include the
for the period A, my lord. Because there are only 2 periods under the new Act. There is no intermediate period.
No intermediate for the court. Yes.
Yes. So for period C, because period B is not there, second period is not there. For period 3, the interest awarded on period 1 will be clubbed together. For example, in this case, the amount of principal sum awarded is 20 lakh rupees. Interest for that period comes to 20 lakh rupees, my lord. Because 10 years period and 12
taken.
So 40 lakh rupees. Now future interest
on that
amount 40 lakh rupees. Yes. Our case is, my lord, that future interest has to be calculated on the principal sum, not A plus B. Yes, my lord. That is the only dispute, my lord. Now, in this judgment, my lord, The Supreme Court was interpreting section 31(7) of the Arbitration and Conciliation New Act and referring to the word sum.
Yes.
And then noticing that there is no word used as principal sum. Principal word has not been inserted there. So the Honorable Supreme Court took a view that this sum will include interest. Now, in my humble submission, my lord, this decision is pure interpretation of New Act, my lord. This is not applicable to section to an arbitration proceeding under 1940. What will
because the word principle has been used?
Because Act doesn't say anywhere, my lord. Section 29 only.
Understand your submission. Yes.
And section 34 is applicable because of GC Rai, my lord. That also talks about principal sum, my lord. And for the period, second period, my lord, now period A on principal sum, period C on principal sum, period B cannot be on the either consultancy cannot be borrowed and given retrospective for that period, my lord. And in this regard, I placed a decision before the court, my lord, that is SD Khoshla.
Yes.
In fact, this is decision rendered much later, my lord. This is 24 decision.
D. Khosla?
Yes, D.
The court is a...
Basis D. Khosla.
August 7, 24.
Yes.
I have this. Yes.
You can see with this printout.
Yes.
Para 2, my lord.
Yeah.
In connection with the contract of 1984-85 between the petitioner and the respondent, award came to be passed by the arbitrator and so and so under the Indian Arbitration Act 1940. So 1940 Act is under the dispute, my lord. Yeah. Now I'll take your lordship to para 11, my lord.
Yes.
Miss so-and-so, learned counsel for the petitioner, argued that 12% interest per annum awarded for the pre-award period is part of the principal sum and it has lost its character as separate interest. Therefore, 15% interest per annum awarded for the post-award period is both on the principal sum and the 12% interest inclusive. This is the contention of petitioner, my lord. In contrast, Ms. Aishwarya Bhati, learned additional so-and-so, on behalf of the respondent, has argued that there is no controversy with regard to the power of the arbitrator to award interest on interest or compound interest in a given case. However, it cannot be paid to the claimant until and unless it is specifically granted by the award or the order of court. In the instant case, the arbitrator has granted interest for 2 separate periods on the principal sum adjudged only, and there is no direction that the interest for the subsequent period would be payable on the principal sum adjudged, including interest for the first period. The sole simple issue herein for our opinion is whether interest is payable on interest or whether 15% interest per annum awarded would be on principal sum award plus 12% annum interest. It is for the pre-award period. Section 29 of that provides that the court may in the decree order interest at the rate deemed reasonable to be paid on the principal sum as adjudged by the award, meaning thereby in drawing the decree the court may order for payment of interest on the principal sum as adjudged by the award. In other words, the court cannot order for payment of interest on interest but only on the principal sum adjudged. Since the award under the Act is in the nature of a decree in terms of Section 17 of the aforesaid Act, it attracts the provision of the CPC also to limited extent, namely insofar as an award of interest is concerned and for the execution of the decree drawn pursuant to the award. Section 34 of the CPC provides that where the decree is for payment of money, the court may order interest at such rate as the court deems reasonable to be paid on the principal sum adjudged. Again, the reading of the aforesaid subsection 1 of section 34 CPC would reveal that interest is payable on the principal sum adjudged and not on interest part of the award. The Interest Act 1978, by subsection 3 of section 3, specifically lays down that nothing in section 3 which permits the court to award interest shall empower the court to award interest upon interest. It means that ordinarily the courts are not entitled to award interest upon interest unless specifically provided either under any statute or under the terms and conditions of the contract. Now, I did not place the Interest Act, so should I place this?
That's okay. Yes.
Under section 3, power of court to allow interest.
Yes.
In any proceeding for the recovery of any debt or damages, or any proceeding in which the claim for interest is in respect of any debt or damages already paid is made, the court may, if it thinks so, allow interest to the person entitled to the debt. So and so. What is relevant is, my lord, subsection 3, clause C, my lord. On the next page, my lord.
Yes.
It says, my lord, 3 says nothing in this section. Then C says shall empower the court to award interest upon interest.
Yes.
So even Interest Act clearly prohibits award of interest on interest, my lord. So para 18 I was reading, my lord. The same provision the Supreme Court took note of that, my lord.
Yes.
Para 19, my lord. In Oil and Natural Gas Commission versus McClellan Engineers, so and so, which was also a case under this act, this court observed that there cannot be any doubt that arbitrators have power to grant interest akin to section 34 CPC, and it is clear that interest is not permissible upon interest awarded but only upon the claim made. In the aforesaid case, the claim made was in 2 parts, and in the second part, interest on delayed payment was also claimed. In that situation, the court held that interest awarded would form part of the damages or compensation for a delayed payment, and it would become part of the principal amount. Thus, in that circumstances, arbitrator has the power to grant interest on interest, which protects the compensation awarded. In state of Haryana versus SL Arora Company, it was observed that interest, unless otherwise specified, refers to simple interest, and that interest is payable only on principal amount and not on any accrued interest. It was further held that the compound interest can be awarded if there is a specific provision under the statute or in the contract for compounding the interest, but no general discretion lies so and so. Para 21, well, in Hyder Consulting, this court was dealing with section 31(7) of the Arbitration and Conciliation Act, wherein for the purpose of payment of post-award interest, the phrase sum directed to be paid by award was used, and it was held that it includes the pre-award interest, and therefore post-award interest is payable on the sum awarded, which includes pre-award interest. However, a distinction was made between 31(7), which simply uses the word sum, and section 34 CPC, wherein the phrase on principal sum adjudged has been used. The departure in the use of the language in the two provisions was held to be of great significance, which clearly showed that the term sum under section 31(7) refers to aggregate amount of the award and the pre-award interest, whereas principal sum adjudged under section 34 refers only to the amount awarded. In case of UHL so and so is again in relation to the interpretation of section 31(7) of the Arbitration and Conciliation Act, wherein the principle laid down in Hyder Consulting has been accepted. In the light of the above legal provision and the case law on the subject, it is evident that ordinarily courts are not supposed to grant interest on interest except where it has been specifically provided under the statute or where there is a specific stipulation to that effect under the terms and conditions of the contract. Well, here I'll pause, my lord. There is no provision in the contract for the award of interest on interest, my lord. There is no dispute as to the power of the courts to award interest on interest or compound interest in a given subject, in a given case, subject to power conferred under the statutes or under the terms and conditions of the contract. But where no such power is conferred, ordinarily the courts do not award interest on interest. Neither the Act specifically empowers the arbitrator or the court to award interest upon interest or compound interest, nor there is any other provision which provides for grant of compound interest or interest upon interest. Even section 34 CPC is silent in this regard, whereas section 3 of the Interest Act specifically prohibits the same. In view of the above legal position, we have to examine the award in question and the decree drawn in pursuance thereof to find out if compound interest or interest upon interest has been awarded. The relevant part of the award pertaining to the interest and that of the decree has been reproduced here before. A plain reading of the aforesaid award and decree reveals that interest awarded under the award has been dissected into 2 parts. The first part relates to the pre-award period from the date of completion of the work till the passing of the award, whereas the second part is post-award period commencing from the date of award till satisfaction of the award. In first part, simple interest 12% per annum has been awarded on the amount awarded, whereas in the second part, interest 15% per annum has been awarded, referring to amount awarded. The amount awarded in both situations have to be the same and cannot be 2 distinct amounts. The amount awarded refers to the principal amount of compensation awarded, that is rupees 21 lakhs and so. The award and the decree nowhere specifically contemplates for awarding 15% interest per annum on the amount awarded, including the interest component, that is the pre-award interest. This is very important. This could not have been done even otherwise, as there is no provision to that effect under the relevant statutes or the contract. No material have been placed before us, or as a matter of fact before any court below, to show that terms and conditions of the contract contained any such provision. In the light of the above discussion, we do not find it appropriate under the facts and circumstances of the case to exercise our discretionary jurisdiction, so and so. So, my lord, in my humble submission, this is authoritative pronouncement on this aspect, my lord. Now, my lord, only one thing I'll like your lordship to just have a look, my lord, the award, my lord. Your lordship is having RFA 6.
1 second. Page?
If your lordship has RFA 6, my lord, then page 39.
Yes, this is FA 6, yes.
Page 39.
39.
39.
39.
No, my lord, this is, where is page number also?
No, where's this is not the Brigadier SS Brady. This is page 42, where is that?
Please see your page number.
Who are we referring to?
Page number 39, what referred to this is the award, my lord. Claim number 7, claim number 8. Page 39.
1 second. No, this is. It starts with the
claim number 7. Claim number 7, claim number 8.
Where, which page are you referring to?
May I assist you?
or 39, okay. Yes. Yes.
So this is discussion on claim number 7 and claim number 8, my lord.
Yes.
Claim number 7 was claim of pre-reference interest at the rate of 24% from the date amount due till date of reference. And claim number 8, interest pendent light and future at the rate of 25% till realization. This was their claim, my lord. Learned arbitrator held, after considering arguments of both the parties, I found that the claimant signed the final bill on 5/2/94 and arbitration was invoked on 5/3/94. The claimant should have been paid all their dues within 6 months of signing of the final bill and arbitration was invoked on 5/3/94. Therefore, the claim is due from 5/10/94. Therefore, I award simple interest on the total awarded amount.
The 12%.
Under claim number so and so, 12% per annum from 5/10/94 to the date of signing the award. Now, date of signing the award, you also seen, is 5/9/2003, my lord. Now, second part, my lord. We are agreed with the second part, my lord. I further allow Union of India a period of 90 days from the date of signing of the award to pay the amount of the contractors, so and so, in terms of the award, and failure to do so, the Union of India is directed to pay further simple interest at the rate of 15% per annum on the total payable amount in terms of the award.
This post-award interest.
Yes. So, my lord, in my humble submission, the wording used, my lord, kindly note, my lord, directed to pay further simple interest. Firstly, it says simple interest, my lord, at the rate of 15% per annum on the total payable amount in terms of the award.
Yes.
From the date of signing of this award. Now, the learned arbitrator, my lord, committed grave error here.
Yes.
If the learned arbitrator in my also forgot that it has to be converted into a decree, my lord.
Yes.
There's one grave error, my lord. And second error, now there's no clarity, my lord. Simple interest at the rate of 15% per annum on the total payable amount in terms of the award. Now, my lord, kindly see the wording used in the previous portion, my lord. Therefore I award simple interest on the total awarded amount. Total awarded amount word used here also, my lord. Under claims number so and so.
Therefore, the claim is due from 5/10/94.
Yes, my
also
lord.
it's a total award amount. He means the principal amount, total awarded amount.
My lord,
Under claims,
my submission was before the courts below.
12% annum on a total on the principal amount.
On the principal amount, and the second portion also has to be on the principal amount.
Yes.
Because
that should be a practical interpretation.
But only because the wording is not very clear, my lord. If you lordship read this again, directed to pay further.
So now they're thinking that on a total payable of
So they filed
12% plus principal amount
So they filed an execution petition for 2.5 crore rupees, my lord.
on this premise.
On this premise, my lord. By giving this interpretation of this award. So ultimately, the learned additional deputy commissioner clarified this. The learned deputy commissioner has not modified the award, not set aside the award. In fact, we challenged all the claims, my lord. Learned deputy commissioner upheld the entire award, only clarified that this interest has to be on the principal sum.
Yes.
Now, in D. Khosla, my lord, the Honorable Supreme Court has said, I'll just highlight that important paragraph once again. My lord. Para 27, my lord. Last two sentences.
Yes.
Just before para 28, last two sentences. This could not have been done even otherwise, as there is no provision to that effect under the relevant statutes or the contract. No material has been placed before us, or as a matter of fact before any court below, to show that the terms and conditions of the contract contained any such provision.
Yes.
So, my lord, this is an admitted position. There is no such provision in the
covers
contract.
your case that award a decree.
Well, it covers factually also. 12% interest, 15% interest. Amount of award is also 19 lakh rupees in both the cases.
Yes.
Any other reason?
You finished?
Well, this is as far as with the cross appeals, my lord. In my cross appeal, I've challenged the claims substantively, my lord.
You changed the claims.
Yes, my lord.
We'll continue after lunch.
But if you lordships are, because my instruction, if you lordships uphold the interest component, I think we will be happy.
Yes.
But before the learned I don't know why they have filed a counter appeal, because before the learned trial court also they said they are not agreed with anything, only they are contesting on the interest part. Now they have filed it. I don't know why they filed the counter appeal.
Counter appeal just for effect, for pressure.
Yes.
To counterbalance.
Well, after lunch?
After lunch, 2 o'clock.
Yes, 2:15 then, yes.
At 2. Wow. Up to you.
May prefer tomorrow. If the 3 o'clock, there's some meeting again. The Honorable Chief Justice.
Yes, we have a full court meeting. Okay, yes, tomorrow. Other hearing matters are there out at 2.
Tomorrow is fixed.
Yes.
What
Short matter I have.
Yes, Lordship.
You've got instructions.
Yes, Lordship. But Lordship, in this case, I'll take little time, Lordship. So
Why?
Because after obtaining instruction is only with regard to 7Q. Now here I have to establish also, because 7Q means on the stay order. The appeal was filed because...
Doesn't matter. It's not that you take a contrast stand for Delhi High Court. That's the only thing.
Yes, but
That's what you have
there
to
is
explain.
also...
Now you have the same authority. Can you take a contrast stand in one High Court and take another stand in the High Court?
Lordship, I'll I'll little bit time. I have to take Lordship to other judgments also, Lordship, because on similar footing, what my submission is on similar footings. There are some other judgments from Calera High Court, as well as the judgment which they have relied on.
That's severable.
It's a
That's severable.
severable.
Severable. You can
Lordship, I'll take.
That's not several nullity. You have to go for appeal.
Lordship, I'll draw Lordship attentions to the judgments also, Lordship. I am prepared today, but it will take some time, Lordship. So I am saying that let it come up tomorrow, Lordship. My case.
Tomorrow will be difficult. It was Thursday.
Then Friday, Lordship.
You'll have to go to next week, yes.
Otherwise, if my learned friends agrees, it can come up on Friday also, Lordship. No problem.
We'll have to take it. We have to next week. Yes. On division bench. That's the problem. Yes, we'll. Yes.
After a week, Your Lordship.
After 1 week. You come prepared because I adjourned it for you only. For how many days?
Lordship, today also I am prepared, Lordship. But it since after lunch also it will. I'll take some time, Lordship. After this matter.
Okay. Yes. This is the matter on item you give again.
41, Lordship.
41, Your Lordship.
41. Yes. MSP for charges submits that she has authority to plead for this court.
Yes, Lordship.
In support of her case. This matter 1 week. Yes. That matter will take up to. Yeah. The other matters.
Lordship, there's an interim order, Your Lordship.
The order will continue. Yes. Other matters will take up to 15 then. How many hearings are there? Yes.
My lord, this matter can have taken consent can be Friday, my lord.
Okay, Friday. Yes.
Well, one matter was there, my lord, that Vidyadhar, it will take a bit of time.
That will take up to 15. Yes.
It will take a bit of time. So
we have 2:15 till 3:15.
My lord, because the meeting is also there, the bar council meeting. Yes, my lord. So can it be taken out 24?
You see, this court will be there 2:15. We want to take out the matter
because it will take a bit of time. Only thing is this: whether we'll be able to complete or not. Otherwise, 24th, my lord, we can fix this matter on 24th.
Up to you. You consult Mr. Chariso is here.
Because 3 of us, my lord, 2 of us are there. The same matter.
Yes. What will be the bar council?
Bar council meeting, my lord.
Okay then.
24th, my lord.
You take the date. Yes.
The 24th.
Well, in item number 14.
You ready?
Can take up after 2 weeks.
Is the first appeal?
No, my lord, contempt.
Contempt
case.
Which matter is this?
Contempt matter, my lord, status quo order was passed by this honorable court. Because it is an admitted fact by them in the appeal, even right from the suit, that we are in possession of the land. We have constructed substantial.
Use valid status quo.
Yes, we have filed a contempt.
Why have you made some construction?
No, my lord.
We
My
were
submission
walking.
is
They
that.
have stopped us from walking, my lord.
My submission is that no contempt lies against us. So, lordship, when we file an appeal before this honorable court, we also file a miscase.
I think you give an undertaking that the suit will proceed and let status quo be maintained. Correct?
Yes, my lord.
Now what happened to the suit?
Now the suit
you
proceed. It's
forget
proceeded.
about contempt. You take orders from the injunction from the trial from the civil court.
There's already a status quo on the
trial court also.
No, passed by this honorable court. My lord, the injunction which was initially given to them, that was vacated by the appellate
Right.
court.
Now what orders are operating from the trial court? Nothing.
Nothing, my lord.
Then you have to file appropriate applications. You have to file section 94
No,
applications.
my lord, status quo was passed by status quo order was passed by this honorable court on the basis of
That's
that.
only that status quo is passed that the matters remanded back to the trial court, and that means that until further orders are passed, the status quo is to maintain. Suppose situation is different, you file an application, then they say fine, injunction granted to you or to him, whatever.
My lord, now the
You have
suit
to
has
hear it.
proceeded, my lord.
When contempt is very limited.
I understand that, man. The only thing is that, my lord, since the injunction order which was passed to them, that was vacated by the appellate court, my lord. So we were walking right from that time, and it's admitted fact by them in the
Okay, come
appeal.
back. We'll hear you at 2:15.
Okay.
Yes.